let me just announce, I've been informed that we have apparently overflow rooms. I know our friends with Capitol Police and the State Patrol are here just to make sure that we don't go over any limitations with regard to the fire code, which we're conscious of. We have overflow rooms in 506 of the Coverdale Legislative Office Building across the street, and closer 125, room 125 of the Capitol, which is literally down this hall and on the left side. There is a screen. It's the same setup as this. It has a screen just like we do right over there that's hidden. It'll come down. So if anybody's here and you're not comfortable at some point and standing for X number of hours can get uncomfortable, you're more than welcome to go ahead and go to 120. I would suggest 125 as opposed to going out in the cold and rain. And you'll be seeing you can see the hearing in real time on the screen that we have set up there apparently. So thank you to whoever set that up because I didn't think of it. We'll go ahead and get started. Let me ask everyone if you could. These things are a blessing and a curse, but I couldn't live without mine. But let me ask you to go ahead and turn it off or put it on quiet or vibrate, something that won't be disruptive as we go along. That goes for everybody, including me. And what we're going to do today is has been advertised and is a hearing only on House Bill 87. What we're going to do, I think the plan of action will be the following. We're going to have Representative Ramsey go ahead and present his bill. For members, we're going to go, as we usually do with more complex and controversial bills, frankly, on a section-by-section basis. We'll go ahead and do questions after each section. I'm going to ask members to limit. We'll go ahead and limit to one round after each section. You're under no requirement to ask a question, but if you do have a question, obviously you're more than welcome to. If we get beyond that section, we're into subsequent sections, and a question comes up that you forgot, don't worry about it. You will have the opportunity later on to ask. I would just simply ask that you hold that subsequent question until the end of consideration on the bill, so we can do our best to stay on schedule and be section by section. We're going to break for lunch at noon. For members, I think we have one of those fancy lobbyist lunches, Chick-fil-A, set up in room 133, and for you to get some nourishment and get some standing time and some energy back. We'll go ahead and reconvene at 1 o'clock. We'll see how far we've gone. If Mr. Ramsey's not completed his presentation, we'll continue it then. And we'll go into no later than 2:30. 2:30. It's Friday. This is Atlanta. There's traffic. It's cold and it's raining. 2:30, so people can get home at a decent hour and off the road. We will pick it up again on Tuesday morning. Tuesday morning at 9:30. I think we sent a notice out yesterday, where we will go ahead and have a public comment at that time, public testimony. I have a sign-up sheet here. If there's anyone who, whether you're as an individual or representing an organization, would want to go ahead and testify, we have this sheet here. I'm going to go ahead and pass this back down. And if Ms. Benfield, if you would just put that at the very end of that table, so if anyone who hasn't signed up that wants to sign up, they can do it right there. I will take that and we'll go ahead and apportion time according to how much time we have and how many people we have signed up, so that we have a fairly tight schedule on Tuesday. But we do not want to go ahead and limit anybody's testimony, limit the ability of anybody to testify. If they wish to, we will have to go ahead and limit the time just for purposes of keeping the wheels turning. But people will be heard if they want to be heard. That's our policy here. With that, members, I understand that we are dealing with a substitute that you should have in your folder, LC 352072S. That is a late substitute, and let me tell you, there will be other substitutes as we go along, and there will probably no doubt be another one probably by Tuesday and maybe even beyond that. I know the author is committed to me that he will get you and get me, frankly, the substitutes in as timely fashion as possible. I can assure you that before we go to a markup, whenever that does occur, that you'll have the latest and greatest substitute that we work off of at that time in a timely manner, and you'll have plenty of time to review that before we do get to a markup. Any questions? Anything that I have? Yes, ma'am.
The summary, is that based on
Thank you for the question. The summary is based on actually the initial legislation, where, and Representative Ramsey and I talked about this earlier, where he is able to go ahead and distinguish between the original, the bill as introduced, and the latest sub that you have in your packet. He will. He reserves the right to have missed something, and if he does, so do I, frankly, and if he does, go ahead and ask the question, and we'll take it from there, and I know Mr. Ramsey will clarify to the extent that he can. I'm told that folks may not, the audio on the online may not be accessible right now. I know in the room the microphones are on, so if our friends in House Communications through the little red light right there are hearing me, if you could just take a look at that and see what we can do to clarify the audio so folks can observe online. Any other questions? Okay. I'm going to ask folks here if they could in the back to try to move a little bit more so that members have a little bit of room in case it's really for your own protection as well. People will go ahead and back up right into you not knowing that you're there. So, plus I want to make sure that we have aisles as somewhat clear as we can, although that's probably a fiction at this point. All right, with that, Representative Ramsey, if you would, welcome, good morning, and the floor is yours for your presentation of House Bill 87.
Am I on?
Yes, sir.
Thank you, Mr. Chairman. I really appreciate the opportunity to be here and talk about this bill. I'm really excited to be to a point now where we're going to get to sit down and have an exchange about the actual words on the paper. And there are a lot of really good and diligent members of this committee. I'm really looking forward to getting feedback on various provisions of the bill. Last week, before I'd even introduced the bill, we had various interest groups coming out and saying it was the worst thing they've ever heard of or could conceive of before they could possibly have read a word of it. So now I'm looking forward to having a real debate with the very capable members of this committee. We have a great tradition on this committee of vetting bills, improving them, catching things that need to be revised. And I look forward to that process. I look forward to everyone's input. I have, over the past week since the bill has been introduced, I've had the benefit of a lot of helpful suggestions from a lot of different groups now that it's out there. And I'm working with anybody and everybody that wants to take time and come in and see me about this bill. I have an open door policy, and I think there are a lot of groups represented in this room here that will vouch for that. At the end of the day, we may not reach agreement on all points, but I am committed to working throughout this process, as I have been for months throughout the study committee process that we had, to working with any person or group that wants to come in and talk about the bill and make any suggestions, and I am committed to continuing to do that. And with that, I want to apologize to the members of the committee for the late date at which you're getting this committee sub. It was finished last night. And to echo the chairman's point, I would anticipate having another sub by Tuesday. We just flat out ran out of time. Terry Long, many of you, if you haven't met Terry Long, she's not our typical committee counsel. She has been working extremely hard. I have done my best to monopolize her time and make her my sole personal attorney in the Legislative Counsel's office. When she sent me the draft of the committee sub last night, it said draft 16. Is that right? Draft number 16, and I think we've still got a little ways to go. But as the chairman said, I'm committed to making sure we get it in your hands as quickly as possible in the future, so you have time to do your due diligence and review the provisions, so we can act accordingly as a committee. Couple of things. First, I think it's useful to put in context the process that we've gone through in developing this legislation. Many of you know back in the summer, at the end of last summer, Speaker Ralston and Lieutenant Governor Cagle appointed a special joint committee on immigration reform. It was an issue we all were hearing about from our constituents back home. And the House and Senate leadership wanted us to take a comprehensive look at the issue here in Georgia, with the goal of ultimately developing recommendations in the form of legislation to the General Assembly on how we can address those problems. I was picked to be the House chair of that effort, and Senator Jack Murphy on the Senate side was picked to be the Senate chair of that effort. We engaged in a several-month process, multiple public hearings, where we solicited feedback from every stakeholder, interest group, or private citizen that had an interest in this issue. It was an extremely inclusive process. We heard from everybody from the law enforcement community, the education community, private employers, a variety of public agencies, and it really was a good process, and it was enlightening to me, and gave me me and the other members of the committee an opportunity to ask a lot of questions and gain a real good comprehensive insight based on a lot of good testimony about the kind of the scope and type of problems we're facing here in Georgia. And make no mistake, the reason that we're here, it's not a problem of our making. It's a problem that's caused by the federal government's failure to adequately secure our border over the last 30 years. We can't control that. We can't control the borders. So the question is, what problems is the fact that we have 425,000 illegal aliens based on the latest study in our state? What problems is that imposing on the state taxpayers, which we're responsible for representing, and what can we do constitutionally about that problem? And I think that's the debate that we're here to have. After the study committee process, we then huddled. The House members on the committee met and worked together, and the Senate kind of went off separately and worked on their legislation. And this bill is the result. This bill is the result of that process. The Senate Chairman Murphy this week introduced a bill on behalf of the Senate members of that study committee. I've had the opportunity to briefly review his bill. There's certainly some overlap, but they're not identical, and I think it's, the Senate's going to go through their process. We're going to go through our process and see how we end up in terms of the various pieces of legislation as we move toward the end of the session. As we went through the process, it was astounding to me to learn the scope of the economic issues, and I think there's a couple of kind of guiding principles here that have guided me through this process as I've learned about it and motivated us to do this legislation. And I think the first and perhaps most important in terms of my duty to the taxpayers of my district and the taxpayers of Georgia is the tremendous economic burden that is placed on our citizens. There's a variety of judgment to determine what you believe, but there are estimates as high as a $2.4 billion a year problem imposed on state and local governments here in Georgia by the presence of the 425,000 illegal aliens in our state. That is, in these economic times, we would be absolutely abdicating one of our fundamental duties, if not our fundamental duty, to protect taxpayer resources, to not look at this issue. It's burdening our schools, it's burdening our transportation infrastructure, it's burdening our law enforcement community, it's burdening our health care system, and if we don't have a duty to look at, especially in these tough times when every dollar counts to taxpayers, if we don't have a duty to look at how those dollars are being spent by the government and to what degree our resources are being burdened by those that are in our country illegally, I don't know what our fundamental duty is. The other principle beyond economics is just the simple principle of the rule of law. We are a state and a nation governed by laws. And when policymakers make a decision, like I believe has happened to a degree in the federal government over the past 30 years, when policymakers make a decision, whether it be a public or private or conscious or subconscious decision, to start ignoring large segments of words on paper in our which is what provides our framework and our institutions. The other issue, the other kind of parallel goal here is to provide law enforcement with greater tools. We want to make sure, as much as we are constitutionally able to do, the law enforcement community has every tool we can possibly provide them to identify the illegal aliens. We can't deal with we can't even get our arms around the scope of the problem until we know exactly who the illegal aliens are and where they are, and tools to adjudicate those that would commit crimes that are in this country illegally. So those are kind of the two kind of guiding principles and goals you'll see throughout the bill. As I said, this is a good opportunity. I'm looking forward to this debate that we can have as members of this great institution, the Georgia General Assembly, that we can have a debate about what's in the bill, absent the overheated, hysterical rhetoric we've heard from special interest groups over the last week. Because I tell you, you're going to hear from a lot of those groups during this committee process, during the public comment testimony, and that's their right, and I'm glad they're here to testify. But I tell you who's not going to be here sitting in this chair testifying. It's going to be our constituents, the millions of Georgians out there that are going to work right now. They're taking care of their children, and they're the ones that are asking us, what are you going to do about this problem? They're not here today. That's who I'm here to speak for, and that's the purpose of this legislation. So with that, I'm going to launch into a section-by-section, very quick summary of the bill. Again, I apologize for the lateness of the committee sub, and look forward to your questions as we go through the process. So, Section 1 of the bill is simply the title. Section 2 of the bill. What we've done, and I'll kind of talk broadly about Section 2, 3, 4, 5, and 6 because they're all related, and I think they're mirror provisions for various sections of the code. What we have now is we have existing law on the books right now. It was passed in 2006. We have a requirement that local governments prior to the dispensation of a public benefit to use the SAFE system to verify eligibility for benefits of the citizens receiving those benefits. We also have requirements that e-verify in the public works contract context that contractors provide evidence of their participation in e-verify, and we have a prohibition on sanctuary cities in Georgia. Those are kind of the three code sections that we're dealing with in these sections of the bill. The problem is what we found out during the study committee process, and I think it was a good opportunity to go back and look. I wasn't here in 2006, but go back and take a look at how that law, the law that was passed, SB 529 in 2006, how it's been implemented and how it's been enforced. And I think a mistake that the General Assembly made back then is they created this obligation, but they didn't put any teeth or enforcement mechanism into the bill if the provisions of those code sections are being either willfully or accidentally not being complied with by the state of Georgia and local governments. So what we've come up with, recognizing the resource drain that we have, we thought, well, what can we do immediately to make sure that we have the best opportunity to get compliance with these laws as quickly as possible. So what we've done is we've created a private right of action for citizens who are able to seek injunctive relief against any government official or agency that is failing to comply with these sections of state law. We are still very much in discussion with members of this committee. I've been actively discussing this issue with numerous members of this committee and various groups about the use of this as an enforcement mechanism, or if there's a better way to skin the cat. But at the end of the day, there has to be, when we come out of this process, real penalties and a real mechanism by which these segments of the law are to be complied with by the state government and local governments. So that's the theory behind Section 2 through 6. We give standing. We put requirements. We require you to be of a certain age and a legal resident of the state in order to have standing to bring one of these suits. But I am and there are this is a section that I'm continuing to work closely with members in various groups to make sure we come up with the very best enforcement mechanism and penalty process we can. And I'm sensitive to frivolous litigation being brought on the state government and local governments. I mean, I know we have Rule 11 as a fallback position for if a frivolous lawsuit is brought, but all of us as lawyers know how often Rule 11 is successful. A Rule 11 claim is successful for sanctions. So I'm committed to continuing to look at that to make sure we have an enforcement mechanism that works, while at the same time doesn't result in a huge proliferation of litigation that's going to cost all of us. So if you want me to pause for questions on these 1, 2, 3, 4, 5 sections, I'd be happy to do so.
I think that'd be good because it's a good conceptual break. Just to put a finer point on it, I mean, we both represent cities. The concern that I would have, that I know we've discussed, is, and my city tells me that they're in compliance and that they're doing what they're supposed to be doing under the law, and I believe them. The only fear that I would have, and you mentioned frivolous litigation, is that if a municipality, local government is in compliance, and of course anybody can sue anybody at any time for anything if they really want to. I would just want some sort of mechanism, or I would hope that we would consider some sort of mechanism so that if you do have local governments that are in compliance or substantial compliance or good faith efforts that go beyond just lifting a finger, that they would have some sort of fortification against frivolous litigation, maybe in the context of attorney's fees in case there is a frivolous suit that comes in. So I know that we've talked about it, but just to put a finer point on it for other members who represent, we all represent local governments. The only question is, do we represent cities and counties, or just counties, depending on where we are?
Well, and as the chairman stated, we've talked about it, and we'll continue to talk about it.
And perhaps an opportunity to cure.
That's right, and we're gonna work through and make sure we provide an effective mechanism that doesn't result in a huge mushrooming of litigation, which ultimately the cost of which is borne by our taxpayer, our constituents,
sure,
their tax dollars.
And you could have a situation, let's say the city of Smyrna believes that it's in compliance, and all of a sudden it discovers something from a system standpoint that we all have computer problems, system problems, small companies, large companies, municipalities, whatever it may be, and unbeknownst to them, and they have a paper trail to prove it. And again, perhaps an opportunity to cure when it's pointed out to them. But that's something that's very doable, and there's certainly a common sense middle ground on that.
And I do want to also point out a change to the members that read. This is, I think, an important change. And it was never my intent to my intent in these 3 separate private right of actions that we provided was to enforce only compliance with those code sections, because we clearly found through the study committee process, particularly in the SAVE and E-Verify context, we aren't having uniform compliance by the state government or by local governments. But when it was originally drafted, I think it was my own fault. It was drafted in a way that was potentially ambiguous, that would have opened up standing to bring suits for failure to enforce other areas of federal immigration law, which is a very broad and complex subject. So we've made a change here to make clear my intent all along, which is that these suits are only to be brought to enforce the provisions of these code sections, the ones that we need to force compliance with, that aren't being uniformly complied with right now.
Mr. Sessler.
Thank you, Mr. Chairman. Representative Ramsey, appreciate your efforts on this. I can tell just from having read through this, the version that's on the internet, you've done quite a bit of homework, and I know it's an evolving process. Just a couple simple questions, and again, this is not a particular area of expertise when we talk about civil litigation. Certainly not an area of expertise of mine. I wanted to ask a couple questions, though. I see here where there's standing for an individual to bring a lawsuit against a government entity. Mm-hmm. Is there any standing in this bill for an individual to bring a suit, perhaps against a business that's engaging in this? Perhaps there's some. I know there's some criminal provisions that deal with businesses. Is there any expectation that could be done civilly as well?
No. The three areas where we grant standing to bring a private right of action by a private citizen are limited to government officials and government agencies.
Is this going to be sort of a play out as a whistleblower kind of a? Is it a Ketam kind of suit? Is it something else?
Well, no, I don't know that whistleblower is the right word, but I mean, it's probably a good analogy in that what is appealing to me about this is if we put exclusive enforcement, kind of a vast exclusive enforcement jurisdiction with a state agency. You and I know how resources are right now. It's probably not going to be rigorously. There's not going to be a rigorous kind of looking over your shoulder process just because it's a function of resources. What is appealing to me about the private right of action is you're literally giving every citizen of Georgia potentially an opportunity to put eyes on their government officials, their government, and make sure these key provisions of the law are being enforced.
And I asked the question because there are precedents, in a whistleblower context where people have a view of things that are happening that are not right. They as a whistleblower, that's available in all 50 states. There's a federal context for that. Again, it's not an area of expertise of mine, but from the perspective of this being something unique, this really, to me, feels somewhat like a whistleblower kind of framework. There's not going to be huge awards here, I don't think, but I think $1,000 to $5,000 plus attorney's fees doesn't. Was that your intent to kind of mirror that somehow? Or?
Well, I don't know necessarily to mirror any whistleblower statute. Again, my intent was to create in these sections an effective way where we as state representatives and state senators can walk out of here at the end of the session with confidence that an important law that was passed in 2006 that's not being complied with by our state and local officials on a 100% basis, we can walk out of here confident that we have a mechanism in place that will ensure that will happen. And again, this is still an evolving. There are a range of penalties and enforcement mechanisms we could come up with, and I'm still kind of looking at those. And again, I'm sensitive to the potential for this big proliferation of frivolous lawsuits because our constituents are going to pay for that. So I just want to come out of here. Whatever we pass out of this committee, I want all of us confident, at least those of us that believe these sections of the law should be enforced, we're confident that we've promulgated a mechanism where that's going to happen.
Mr. Peck.
Thank you, Mr. Chairman. Thank you, Mr. Representative Ramsey, for your work in the Joint Commission and also for drafting this bill. Regarding the sections 2, 3, 4, and I know that Chairman Golick had concerns about reading into a good faith, perhaps a safe harbor type of rule within the statute, the cause of action. My question is, in a situation when you have an underfunded local government where their internal controls breaks down because they don't have enough staff to do these checks, is that going to be perceived as a violation? And the concern that I have is if, in fact, that lack of money and resources is causing the violation, the penalty is more money being drained from the local government. Do you have any plans or any conceptual ideas about how to carefully characterize a safe harbor so that we could account for those type of situations? Well,
I think it is a good notion that we come up with an opportunity, kind of a cure period, if you will, if we can figure out. And I've thought a great deal about that, and the chairman and I have spoken about it. I've spoken with a variety of folks about it. A cure period, if you will, because I'm not going to sit here and say I believe this is being willfully ignored systematically. I don't think that's the case. But the General Assembly in 2006, and I agree with them, put these requirements in place, and I think they're important requirements that need to be enforced, and that's not happening on a uniform basis right now. So I'm committed, as I said, to working with you, and I want to tell you publicly I appreciate how much I've appreciated your insight throughout this process. Your background as a federal prosecutor has been invaluable to me, and your insight has been tremendous. I'm committed to working with members of the committee to make sure we do this in a way where it's enforced by every government in the state that's required to comply with this section law. It's not just local government, the state government as well. But it's done so in a way where people that are unknowingly violating or not complying with the law are given an opportunity to cure and comply with the law, which was passed by this body 4 years ago.
Let me ask you, Mr. Ramsey, if you would, just to have one microphone toward you or not, because it's messing up the system audio. Great, thank you. Yeah, okay. Ms. Abdul Salam.
Thank you, Mr. Chairman. Representative Ramsey, obviously a lot of hard work has gone into this. I guess following up on a couple of points, Representative Setzler brought up the concept of whistleblower. In my mind, I guess what I'm looking for answers on is the potential perhaps for the right of action that I might feel entitled to if I'm constantly calling the police and saying, I think I've got a house full of illegal Russians living next door to me. And the police just says, never mind, I'm not going to investigate. Would that even arise to a level of a right of action if they never take any action? I can't take any action against the police if the governing body doesn't do anything.
No, and I think that's a fair point, which goes to the clarification that I've made in the committee sub. I think some people, and again, this is an evolving piece of legislation. The original draft of the private right of action could potentially have been construed to expand beyond enforcement of these specific code sections. It had language that said the purpose for failure to comply with this code section or federal immigration law, which I think could have potentially opened up a can of worms and given an opportunity for litigation to be brought by private citizens in a way that I never intended to in this bill. So I think now it's crafted in a way, and it's narrowly crafted, where the only areas that a citizen will have standing to bring a suit in are the enforcement of the E-Verify in the public works contract context, the requirement to use SAVE in the public benefits context, and in the sanctuary city context. So a law enforcement officer being called by a citizen to come and look at a house of Russian immigrants, that's not an issue that would be dealt with in those three code sections, so that wouldn't be applicable in any way.
But it's still an immigration issue.
Well, it's not an issue in this private right of action context.
But it's still in the bill. It's still a part. I mean, and I guess that's what I'm trying to say.
What's in the bill?
It's still a broader issue in the illegal immigration conversation. And so how do we separate them or we merge them? Is there an opportunity to even do that?
I guess I just don't understand your question. We're talking about these sections, and I think you were asking me, could these three private right of actions potentially expose a law enforcement officer to a suit for failing to respond in what a citizen would believe an appropriate manner to a call that there's an illegal alien living next door to them? I don't believe that this bill can in any way be read to expose an officer,
a law enforcement agency,
to that situation. That being said, if and I've had significant discussions with the law enforcement community and continue to, and I'm open to further clarifying it, but I'm confident now that my original intent, which is to enforce the provision, these three state laws that exist, the private right of action we created are limited to those three segments of state law.
Okay, but one further follow-up, Mr. Chairman, if I may. So if it goes to the point and the governmental agency takes action, if they are actually found to be some reason for cause in their process, how would a citizen know that there's a violation or potential violation in E-Verify? How would we, regular neighbors, know that there's something going on with E-Verify?
Well, I would think I mean, there's probably a lot of examples that you have if you're for instance, a contractor, and you apply for a public works contract, and the government official never asks you for your E-Verify affidavit, and you're a citizen of that community, and you know it's a state law, and they didn't ask you for it, so you're going to know that my city or my county is not, or the state is not enforcing this requirement that is placed on me. I think there are probably many scenarios we could probably come up with where a person could learn that one of these segments of the law are not being enforced by that given jurisdiction.
Thank you.
Mr. Cooper.
Thank you, Representative Ramsey. Thanks, Chairman. Representative Ramsey, we've all talked about this issue of illegal immigration for a long time, and it's important to all of our communities in this state and to the state. And I really have two questions. The first one is a follow-on to the issue raised by Representative Pack, and it may be appropriately addressed to Legislative Council, but my understanding is before any person can file a claim against a public entity in the state of Georgia, be it a county, a city, or the state, they first have to file an ante litem notice. First of all, is that correct? Would that apply in this situation? And if it does, then wouldn't that in fact help cities and counties avoid the litigation part of this code section by giving them an opportunity to correct their misconduct?
Well, and that is a good point. And what we're wrestling with is if in order, and I think there's a general consensus that there does need to be some kind of opportunity to cure before litigation. And I'll let counsel speak specifically to your procedural question. But what we're kind of wrestling with is who is going to make the determination that the violation that's being alleged has been cured, but to the citizen bringing the complaint satisfaction, because there has to be an arbiter. If we're giving a cure period, there has to be an arbiter that says, okay, the State Department of Transportation, they've now adjusted their procedures and are now adequately complying with the law and is addressing whatever that citizen's concern is with respect to that agency or that official. Terry, I don't know if you want to speak to the procedural question.
It's been a while since I've looked at the Tort Claims Act. It's my understanding that originally it was intended to deal with damages issues, and we don't have that here. But certainly it's a good suggestion. We need to review that and see if we need to tie it in. So be glad to do that.
Thank you. My second question is really more of I guess you'd say it's a technical question. Looking at Section 2 and Section 5, there's language that says a legal resident means a resident as defined by Code Section 40-2-1. 40-2-1 is the Motor Vehicle Code, and it defines a resident basically as anybody who lives in the state for 30 days or more. But then there's another provision in Section 4, subparagraph A3, I'm sorry, let me see if I can find line number 101, page 4, that defines legal resident as a person who's lawfully present and has other provisions that seem on their face inconsistent with the code section we've referenced in Section 2 and 5. I think that may be an issue we need to address.
And the reference to the Motor Vehicles Code was put in last night. It needs to be put in there as well. That's a error on our part. And the reason that was the definition that you just read is the definition we had in there originally. And then we thought, why reinvent the wheel when we already have a definition of a legal resident existing in state code? So we decided to cross-reference it to the Motor Vehicle Code. So in the next committee sub, which is already in progress, that line 101 to 104 will cross-reference the same code. So we appreciate the catch.
So does that mean we're taking out references to language in line 101, 102 that says any person or a person who is lawfully present in the United States?
I don't believe that in terms of in this context that it's necessary, but I certainly am willing to hear the suggestions of the members of the committee, and this is not a point I'm any way wedded to, and would be happy to hear your thoughts and the other members' thoughts on that definition.
Thank you.
I mean, the goal in kind of providing conditions on standing is to help make sure you have a vested interest in the state in order to bring an action. So thank you.
Thank you,
Mr. Coomer. You've given us a good example as to exactly why we have these hearings, and to go through the bill again and again and again, and there will be new things that come up here and there, and that's why the process is slow, so that we can go ahead and catch things exactly like that. And I appreciate your attention to detail on that, and we'll need more of it as we go along. So, thank you,
Mr. Chairman.
Mr. Atwood.
Thank you, Mr. Chairman. Representative Ramsey, I want to thank you for your diligence and your hard work in this area, but I wanted to publicly thank you for including the freshmen in this. You've been very open, and I applaud you for your openness in that and considering our concerns. As a former magistrate judge and attorney, but also a federal agent, I know how very hard it is to wrap your arms around this particular type of legislation, and I want to publicly thank you for your service and your diligence in that. I noticed in your opening remarks, though, that you mentioned around a 10% unemployment rate. I don't believe that factored in the hardcore unemployed, which would drive that up to around 17%.
You're exactly right. The reported unemployment rate certainly doesn't reflect real unemployment. You're 100% right. And I want to thank you and Representative Pack and others. This is a tough issue to come in for your first big issue you're dealing with, and we're really not giving you all a learning curve, and your input has been tremendous, and I will be relying on it as we move forward.
Sure. Thank you, Mr. Chairman.
Thank you. I said in the organizational meeting, if you recall, that new members are here for a reason, and it's to bring the expertise and the experience that they have, and it's valuable. And as you can tell, we're already using it, and that is by design, and that's the best interest of the taxpayer resources. So thank you for your work. Any other questions from members on what I'll call the private right of action sections in general? I mean, they extend over several sections, but the concept is the same. Seeing none, Mr. Ramsey, let me ask you to go ahead and dive in then, beginning in Section 7 of the bill on page 6.
Section 7 creates several new criminal offenses, and this is a statute that very closely mirrors an existing federal statute. It is also a statute that has been promulgated by several states in recent months. Of course, everybody. The big news last year was the bill that was promulgated by Arizona. They have a similar provision in their bill, and other states since that time have put a similar provisions on the book. And really the goal is of these three sections, or of these three offenses, is to get at the people that are aiding and harboring and giving and giving assistance, knowingly giving assistance to illegal aliens to come to our state, to remain in our state and our country unlawfully, and to come here in the first place. What we've made some changes since the bill the bill that was introduced in a way that I think that will certainly help in terms of a potential court challenge. What we did, this is a section. This specific section was not part. It was a part of the section that was reviewed by the federal circuit judge in the Arizona case and was not enjoined. She expressly allowed these similar provisions to become effective in Arizona, and weren't one of the three sections that were enjoined by that court.
Mr. Ramsey, let me just I apologize for interrupting, but let me just make sure that's clear. What section specifically are you referring to?
I'm in Section 7.
And
the entire
individually
Section
7.
Yes,
okay.
Section 7 of the bill.
Thank you.
The line 166 through 280. No, I'm sorry, I skipped a page. To line 231. On 231, the change the change I made in this committee sub as opposed to what was drafting, it was really my thought process was, we've already had a judge look at this section, and that is a judge that that in my opinion got a lot of her opinion wrong in the Arizona case. But she looked at it and upheld this, and the difference was that originally in mine it was a standalone. It was a standalone offense. The harboring knowingly harboring an illegal alien, knowingly transporting an illegal alien, knowingly inducing an illegal alien to come to the state of Georgia. And so I made a couple of changes to I think further kind of shore it up from a legal challenge standpoint. Originally, it said you could be prosecuted for knowingly doing those things or recklessly disregarding the fact that a person is in the country illegally. I talked to a couple good friends of mine that do appellate litigation, and they recommended that we remove the recklessly disregard. It created, and it really wasn't the type of conduct I really want to get at here. I really think we need to get at here is the person that is knowingly committing the conduct. We don't want any vagueness, I think, in this offense. So we removed the recklessly disregard, so that you have to be proven to have knowingly committed these acts. And the other change we made is we made it, and this was in the Arizona bill as well, and part of the provision that again was upheld by the judge, was made it a counterpart offense, in that you couldn't charge it as a standalone. It could only be brought if these acts were committed in connection with another criminal offense. We've made a distinction in terms of the number of illegal aliens that you are transporting or harboring. The distinction, I think there's a good policy reason for that distinction to be made, in that we want to get at and treat more seriously the folks that are doing this for commercial profit, the individuals that are operating an enterprise where they're profiting from inducing illegal aliens to come to the country and then essentially selling them into indentured servitude for various professions around the state. So with that, I'm happy to take any questions on Section 7, Mr. Chairman.
Mr. Ramsey, let me just to make sure it's clear to members in terms of either in connection, getting back to your point, in connection with a separate offense. Correct me if I'm wrong. It's entirely I assume that is to address the concern regarding this sort of random
the person that accidentally, which I don't think anybody could have been prosecuted for this. For I heard some silly examples that what about the Greyhound bus driver? And I think the way it was drafted originally, that person couldn't have been prosecuted for transporting an illegal alien. But I want to make sure that those kind of there's no possible way where there is a person that unwittingly commits one of these acts, and I think removing the recklessly disregard and requiring that it be done in connection with the commission of another criminal offense just narrows it to make sure those kind of unwitting acts aren't swept up in this.
Mrs. Cooper.
Thank you, Mr. Chairman. Now, being a non-lawyer, this is a friendly question. So, what kind? Somebody is actually truckloading illegal aliens into our state, and that they're housing them all, in bad situations and so forth, and that, but we have to wait for them to do what? Drive drunk, get picked up and pulled over?
I think any criminal offense could serve as the kind of predicate to bringing one of these, whether it be you just go through the whole range of the criminal code that has to be done in connection with. And again, this is one of those points where I made that change. I made that change in the most recent committee sub, anticipating that there are. I'm certain there are groups that are looking at ways to challenge this law, and it just made sense to me that we've had a federal judge that has already looked at this type of provision and held it to be constitutional. And in several of the changes throughout the bill that I've made in the committee sub were aimed at addressing potential concerns from a lawsuit standpoint, and that was my motivation. But this is one of those points, though, where I'm certainly open to hearing the opinion of the committee members, and I want the strongest bill possible that is constitutional.
Mr. Chairman,
and if there is a suggestion on these criminal offenses from members of the committee to strengthen it in a way that we're confident can pass court muster, I'm all ears and certainly willing to hear that input.
well, while I have some concerns about people being able, just the average person, or perhaps bringing multiple lawsuits against our counties and the state, and I hope hear you that you're going to work on that area, but I think the most egregious part of our immigration problem are the people who are preying on innocent, or on people in Mexico who are, or wherever, who want to work for a living, and then bringing them in and often in very bad circumstances and mistreating them and bringing them in illegally and taking their money. I think that's one of the most egregious things we have, and to have to wait for that person, because what we're saying basically, if that person always abides by every other law, they're going to get away with it.
There are human trafficking statutes that could be brought to bear in this context also, but I've potentially and this is something that's kind of evolving from a thought process. Sorry, Mr. Chairman. From a thought process standpoint, I would certainly, and I'll commit to looking at that very point with the prosecuting attorneys council and others to make sure there are tools there, particularly the folks that are doing this for commercial profit.
Right.
We want to be able to aggressively go after folks that would do this for profit. That is a current day form of slavery, and it's a despicable act, and we need to make sure our law enforcement community has the tools to aggressively pursue it.
Thank you. That was my concern.
Just to put a finer point on it, I mean, we're talking. You've removed the reckless disregard language in order to get rid of the ridiculous examples of, let's say, the Greyhound bus driver and so forth. But I mean, the objective is still the ongoing criminal enterprise of human trafficking as it relates to illegal immigration.
Well, certainly the tougher sanctions are geared towards those.
Right,
absolutely.
But that can occur incident to any criminal violation.
Right.
It could be incident to a traffic stop.
Sure.
I mean it. So I mean, and that's no change from what we have right now.
Right.
Oh, okay, just want to make sure that's clear. Ms. Neal.
Thank you, Mr. Chairman. I'm not familiar with the last name in reference to Sharon's statement, and just as a general comment to you, Mr. Ramsey, I don't, as a police officer myself, I don't see any legal way to write any portion of this bill to avoid any type of profiling as far as anything outside of a vehicle. I can't think of anything that would legally hold up in court as being a reason why a police officer would come to a home outside of a criminal offense, like the typical 911 call. I don't see anything that won't be racially motivated that would help this bill. So I don't know if that'll be a good idea to address that or not.
Well, Representative, I really appreciate your perspective as a member of our law enforcement community, and if you could point to me to a provision in this section or in the bill that is giving you concern, I'd be happy to speak to it. It's tough for me to. I don't think there's anything. In fact, we have an express prohibition in a subsequent section against the use of racial profiling, but I don't think there's anything in this bill that is going to result in that. But if there's a specific line number, section number that you can point me to, and I'd be happy to meet with you privately to go over it.
Well, I was
but
just
appreciate
referencing
your
Miss Sharon's comment about looking into it. I was just trying to explain that, as far as you are concerned, it'll be very tough to try to add that piece in here to avoid the profiling issue. There's nothing in here now. Like I said, I went through it with a fine-tooth comb a few times, but I don't see anything in here now. But if you were thinking about doing it later, I don't see a way.
Well, I'm Representative Neal. I'm going to be extremely diligent and conscious in attempting to whatever additional revisions we make. I will always be mindful of the considerations of making sure we don't run afoul of the state and U.S. Constitution.
Okay.
Thank you.
Just to be clear, I mean, there is a provision in the bill, and I don't know exactly where it is in the new draft that we got this morning, but there is a express prohibition on such conduct. Is that correct?
Well, it certainly that's the next section we're going to talk about.
Okay.
But in that context, absolutely.
Okay. Mr. Setzler.
Thank you, Mr. Chair. Thank you, Mr. Chairman. To the author, I'm still unpacking this this addition you've made in your substitute. The person acting in violation of another criminal offense. Could I ask you a couple, for examples, just to kind of help clarify and to see if it's within your intent? And I'm trying to understand, why it's necessary to have this other underlying offense tied to it. For example, take the harboring, the concealing, harboring, or shielding of an illegal alien. I mean, let's put sex trafficking aside for a minute. Let's take sort of the garden variety. You've got a person here in Georgia that has 2 known illegal immigrants that just came into the country. How they got there is perhaps irrelevant, but they know these people just got in Georgia. They're trying to get established, trying to find a job, trying to do those kinds of things, and they know for a fact that they're illegal, whether they're being paid to keep the people or not. It's crystal clear this man and these 2 men and this woman are here illegally, and she knows she's keeping them in the upstairs bedroom. To me, I don't know that there's any other underlying offense there that would trigger this, but to me, that's misdemeanor activity, and I wouldn't want that to not be dealt with.
And that is ultimately the 2 changes I made in the section. One, I think, is a clear, necessary change from withstanding a potential vagueness challenge, which is the removal of the reckless disregard.
Okay.
I think that in connection with another criminal offense that I've added, my primary motivation there was this has been passed on by a federal judge. It's language that other states have used, and gets at the main problem I'm seeking to address here, which is the folks that are really, at least with the more serious consequences, the folks that are doing this intentionally and systematically as part of a commercial enterprise. As a policy matter, I don't disagree with you, and if the members of the committee ultimately believe that during the bill markup that this is a point as a policy matter that we think can withstand court scrutiny and provide a stronger bill, I would love to work with you on that point. So I think it's my motivation on that point was that there will almost certainly be a court challenge brought if we pass a significant bill. There are a lot of special interest groups lining up out there to bring a challenge, and with respect to these provisions, we have language that's been passed on already by a federal judge. So, but I'd be happy to work with you on that.
In the circumstance I shared, perhaps there's conspiracy to commit some other series of things, but that may be part of it. And we can continue the conversation. Mr. Chairman, if I could ask one follow-up as well. And some of these things can be handled, as we work as a team offline. I wanted to. I know as you're working on substitutes, you ask members for input. So One question I did have back in Section 7, or really all three of these sections, is what's the treatment for folks who are themselves illegal and are committing these offenses with respect to their immigration status? If there's a person who themselves are illegal that are participating in these crimes, one that commits a misdemeanor, one that commits a felony, from the standpoint of disposition of staying in this country, not being allowed to stay in this country, how they're handled by federal authorities, could you draw the distinction for the committee there?
Well, there are that is really the answer to that question really depends on who's in the White House, how that given administration is enforcing immigration law. Right now, the ICE is really only it's kind of prioritizing from a resource standpoint, really only taking felony offenders. So that is an evolving administration to administration, how a person that is identified as being in the country illegally, how they're treated by federal authorities. That's really a function of how that given agency, that given year, based on the resources they're appropriated by Congress year to year, is treating them. Right now, it is primarily they're primarily focusing on taking felony individuals that commit felonies off of state hands and into federal custody.
Is that a written policy, or is that just the practice? Is there a written policy that says folks that commit, a misdemeanor, a battery, you name it, still have to be handled in the same way, or is that just an unwritten?
I'm sure the ICE has promulgated rules written down. We could probably track down. So.
Okay. The point, the exchange a minute ago, I think, is Mr. Ramsey, is very important in terms of a threshold determination for this committee in the context of must action by law enforcement be incident to another offense. I mean, you can think of any number of situations where you have an individual bragging to his. I mean, you hear things all the time. Somebody bragging to someone else, I robbed this, or I stole that, or I'm the one that did that, and all of a sudden that person gets picked up. Well, that in and of itself isn't a criminal offense, but another individual has come by information, and they tell two friends and so on. All of a sudden you have two or three people swearing out an affidavit to a law enforcement officer, and a warrant is executed. So, but there's no underlying criminal offense at that point other than the good faith testimony of one or more people about what so-and-so, the actual subject of a particular potential crime, has told them. And so that's something I think we do well to keep in mind as a real-world example of what does happen and what we need to think about as we consider that particular threshold determination, which really starts with the first determination of, is it constitutional? And we do well to go ahead, I believe, to take notice of not necessarily be instructed by what happened or what didn't happen, or what was ruled upon in Arizona. But if a court, in the Arizona court, upheld a certain provision, I think we do well to take notice of that. Is that determinative? No, it is not. But it's certainly something to keep in mind. Is it constitutional? If it is, and it passes the straight-face constitutional test, as I would call it, then it becomes a policy matter. So I would suggest that we move in that deliberate procedural direction as it relates to what I believe is a very important threshold determination for the community to make, not right now, but as we get closer to a markup. Mr. Coomer? No? Ms. Neal?
I have one question. Can you just clarify for me, and I've been trying to look for it, just simply on face value, if you are an illegal immigrant, is a misdemeanor or felony based on your bill?
We don't have. There's not a state that's federal law. We don't have a state statute criminalizing a person's immigration status in Georgia.
Is this bill trying to do that?
This bill does not create a state offense based on an individual's immigration status. No.
Okay, so I guess this is a hypothetical. If a police officer were to pull over someone who's an immigrant for speeding or what have you, get their information, find that they're not a citizen, being that the charges they're going to have are misdemeanor charges, being that ICE only does an ICE hold at the jail for felonies.
I don't think that's true. It depends on their
Circumstance
I think we're going to
surrounding
hear
it.
from law enforcement officers later that from counties that are enrolled in the 287G program,
Okay.
which is different. It's a very different process. So, and I think the kind of the roadside stop is the next section we're going to get. I suspect
Okay.
we'll probably talk a good bit about it.
Yeah.
That's the next section I'm going to. I don't know if you want to close the loop on this section first before I jump into that to address Representative Wood's question.
No, I think it's a good time to segue right into that. And I think what you'll find, Representative Neal, is that a lot of times, a lot of the local law enforcement agencies, that my understanding is secondhand from what I've been told by my sheriff's office and by our traffic court judges in Cobb, is that a lot of times these processes begin with a traffic stop that results in a no license charge.
Right.
No license, no nothing. And that's how the process begins.
That's exactly correct. That's
Yeah.
correct.
Okay. Any other questions on Section 7 for the author? Seeing none.
Section 8 is a provision that has been much discussed over the last many months. It's the debate on this provision started, at least from a state standpoint, with the Arizona bill. Subsequent to that, other states have enacted similar provisions or in the process of enacting similar provisions. I will say this provision right now will be, it is, I'm working closely with members of the committee and legislative council to make some fairly, well, I'm not going to say significant, but some revisions that are hopefully going to make sure that law enforcement officers are not put in a tougher judgment call position than they have to be. So I think it might be useful to talk about kind of the conceptual and the broad goal. But in terms of this specific provision, this is a section that is being revised right now and will be a part of a committee sub. The broad goal here is simply this. Right now, in Georgia, when you are booked into a jail on a felony charge, your citizenship or your immigration status is verified. A subsequent section and this section do is expand that process to a misdemeanor, which is a subsequent when individuals are booked in on misdemeanors, and in this section, in the course of a criminal investigation, which there's never a criminal investigation where the law enforcement officer doesn't attempt to determine the identity of a suspect, but in the criminal investigation process, whether it be for the process of adjudicating a traffic offense or a murder or a bank robbery, whatever the context is, this gives law enforcement an opportunity in the context only of a criminal investigation. When you have a criminal suspect who a law enforcement official has probable cause to believe has committed another criminal offense, this gives that officer the ability, if the individual can't provide, we list a series of documents that are kind of standard documents a person would have on their have access to and to prove their identity. If they're unable to provide one of those, this gives the law enforcement community an opportunity to seek verification. It's not a mandate. They're authorized to seek verification. It's not a mandate because it's so. The process of seeking verification is the resources different law enforcement communities have access to is different depending on what part of the state. You have several counties now that are engaged in a pilot program where they have a kind of a roadside fingerprint machine where they can use to access federal databases, and this is literally something that's going to be evolving from month to month and year to year. So we didn't prescribe the method by which you have to seek verification because that's different from jurisdiction to jurisdiction. And we didn't make it a mandate that the verification process occur. We authorized the law enforcement as part of their investigation where they're always going to be attempting to ascertain an individual's identity as part of a criminal investigation anyway. This will authorize them to inquire as to immigration status as part of that process. Again, I apologize I didn't get the revision of this done. It will be done by Tuesday, so we can really focus on the specific provisions, which I think will again, I don't want to term them significant. It's not going to in any way diminish the intent or the goal, but I think it's going to be reworded in a way that will hopefully make sure law enforcement officers aren't put in a bad position from a judgment or discretion standpoint. So with that, I'd be happy to take any questions, Mr. Chairman.
Questions on Section 8, Ms. Neal.
And actually, thank you, Mr. Chairman. I think this might actually lead into another section, but just as far as when the officer makes the arrest, and then having to either wait on the proper federal officials or do the arrest or what have you, and you can guide me as well, Mr. Chairman, if I'm wrong or not, or is this the place to ask this, but is there a financial piece that can coincide with especially this portion of the bill as far as helping public safety have the means to do this? Because a lot of them are understaffed, don't have the equipment. Like, for instance, my agency, the fingerprint roadside thing, I think we don't have like one.
Right.
And because they're so expensive.
Right.
Is there a financial piece that can be added to help public safety be able to have the adequate amount of resources and personnel to even be able to handle this?
No, that's a very good question, and you know the budget times we're in. You haven't been here long, but I'm sure you're starting to get a sense for how tough our budget is in this state. If we had the means as a state right now to do that, we would, which is exactly why, and we don't, to fund some statewide verification tool for the law enforcement community, which is exactly why we drafted this in a way that it's not a mandate that you have to do this, and B, we don't prescribe the method by which you have to seek verification, because that's changing also, and that's a function of the federal government. They're tools in terms of providing state and local officials with a means by which to verify immigration status. That's an evolving process as well. So I think given the budget times that we're in, the way this is drafted right now is kind of drafted in that context. But certainly in years ahead, as hopefully revenues improve, I am 100% committed to looking at ways we can plug more resources into enforcement of the laws we're promulgating here and across the criminal code. So thank you.
Mr. Atwood.
Thank you, Mr. Chairman. Representative Ramsey, isn't it true that now once a police officer lawfully stops someone or arrests someone, there's a series of federal databases, I believe, that they can query, National Crime Information Center, National Law Enforcement Telecommunications Center. I know before I became a federal agent, we often would work with the El Paso Intelligence Center to query NATIS, to query text, the Treasury computer system. This is just one more tool, isn't it?
I think the representative knows of what he speaks.
Thank you, sir.
Mr. Prack.
Thank you, Mr. Chairman. Quick question. I missed a portion. I don't know, you might have testimony during the joint committee hearings on this. Question regarding how long, on average, does the database query take? I know circumstances generally change during any traffic stop, and you, as a policy matter, I'm more on the side of giving more discretion to the police officer given the dangerous circumstances of a traffic stop. But I think from a legal challenge perspective, I would like to know what the average time for that database check is. And if an officer stops somebody running that check, certainly we don't intend, I don't think you intended to somebody be held on the roadside for hours on end.
No, and that's that's one of the revisions we've actually made in the bill that we've talked about. Originally, and this was another one of those my friends that do a fair amount of appellate work, we originally had a provision where even after the probable cause on whatever the predicate offense had expired, the law enforcement officer could detain the person to complete the verification process. I took the advice of a couple of folks that are a lot smarter than me and said, you're probably going to have some issues in terms of a facial challenge, and it really needs to happen in the context only of the criminal investigation. And once that probable cause expires on whatever that predicate offense is, you're going to have a real tough time from a constitutional standpoint making an argument that it's okay to detain an individual beyond that point. So we remove that. In terms of giving you a time for the average query, I'm sure we could try to track that down. But we made clear in the revision that this verification process can only occur during the course of the criminal investigation on the offense. And once that probable cause, once that time limit for that lawful detention, and this has to be done in the context of a lawful detention, expires, the suspect must be let go.
Are we talking 48 hours? What is the time frame that you're talking about in terms of the lawful detention?
I'm talking about the time in which a criminal suspect is detained by a law enforcement officer. The verification process has to be conducted within the context of that investigation in terms of the time that he's detained for the probable cause on the other criminal offense.
Okay, but there's a limit. Can you speak to the limitation in terms of time that what that is specifically?
Well, I think it would. I think it would depend on the criminal offense and the circumstance. It's really a fact base. I don't think I can really draw you a bright line there, because it really is literally a crime and fact, circumstance by circumstance case basis.
All right, I think we may come back to that.
Okay.
Right. Ms. Bird. I'm sorry, Ms. Abdul Salam.
Thank you, Mr. Chairman. I noticed that the next section, Mr. Ramsey, talks a lot about the federal requirements that, of course, should be governing the immigration issue overall. I guess I'm concerned with all of the work that's already been put into your legislation, into this legislation for Georgia, and we know that the federal component itself is ever-changing. What is the concern, or what safeguards are we taking to make sure that we're not writing good legislation and they're changing it as we speak?
Well, I'm not sure. I think the provisions of the bill, I think the bill has been drafted in a way that contemplates a fluid federal body of immigration law. So if there's I don't think there's a provision where a change in federal immigration law on a point is going to necessarily diminish or put us in conflict. So.
Thank you.
Mr. Coomer.
Yes, sir.
Mr. Setzler.
Thank you, Mr. Chairman. I wanted to kind of get back to the line of discussion dealing with the reasonable suspicion. And if we take a standard traffic stop, maybe it's a speeding, it's running a red light, reckless, maybe marginal reckless driving, something that leads to a traffic stop. What I heard you say was, while that traffic stop happens and while the driver's license information, those kind of things are being run, if there's reasonable suspicion that the person may be an illegal alien, and it's currently within the purview of law enforcement, if there is reasonable suspicion to do this check today, is that not the case?
I don't think that's the case. I don't believe that to be the case in the context of the traffic stop.
So in the context of an existing traffic...
Right now, the existing law, there is an obligation on jailers to do or to do immigration status verification when in the jail context when arrested on a felony offense. That doesn't extend to misdemeanors, and it doesn't extend to criminal investigations, which would include moving violent traffic stop.
And I know there's no duty on the law enforcement officer to make the check today, but is there a prohibition if his suspicions raised to a reasonable suspicion threshold? Is there a prohibition from him running or contacting someone and doing an immigration check today under existing law?
I don't know that there's a prohibition. I think without express state express state sanctioning, it would potentially put a law enforcement officer that was doing that today in the traffic stop context would potentially cause some legal problems. I think that's why it's important that we expressly set in state code the parameters by which the law enforcement community is authorized to conduct these verifications.
Okay. Could you help me understand, you talked about when the underlying predicate probable cause disappears, for example, the traffic stop's over, the ticket's been written, and the person's otherwise ready to be released. But if at some point, if this is passed, the reasonable suspicion goes to maybe a probable cause threshold, would there be an ability then to detain someone for the immigration status issue?
No, well, because remember, we don't have a state crime that penalizes a person's status. So I think, for instance, you're investigating a bank robbery, and in the course of that investigation, you develop the reasonable suspicion to believe that the individual that committed the crime is also in the country illegally. They perhaps provided you with obviously fraudulent documents that are forged, and that gives rise to that reasonable suspicion. But during that criminal investigation, you find out, this guy didn't commit the bank robbery. You couldn't then detain him beyond once that probable cause it goes away. You couldn't detain them to complete the verification process. You would have to release him. Now, there's nothing to stop you from independently of that. You have the person's information from conducting the verification process without the suspect detained. But remember, we're talking about detention from a constitutional standpoint. We're talking about detention of an individual.
Right. And I guess what I'm saying is if in the due course of that traffic stop playing out, if the records check or whatever investigation that's pursued pursuant to this Section 8 is executed and the reasonable suspicion is raised to a probable cause level, I don't know exactly what that would have to look like. That we can talk about that some more. But if that were the case, and this were a law enforcement agency that participates in 287G, isn't it true that a law enforcement officer that has probable cause of having an illegal immigrant today under custody has the ability to? Isn't it true today that a law enforcement officer that has actual probable cause that an illegal immigrant's in his custody, isn't it within their purview to not just release him back on the streets, but to kind of detain the person?
The only reason in your scenario, the only reason the person, whatever other criminal violation that made you come in and made you lawful, put you in a position where you're lawfully detaining a person to investigate that criminal offense. In your scenario, that criminal, the predicate has already been resolved.
Correct.
In your scenario, the only reason that the person is being detained at that point is for to verify immigration status
based on probable cause. If you pulled someone over for doing 80 and a 45,
that goes to the heart of why I took out the authorization to do that, because I think without a state statute making it a criminal offense to be based on a criminal offense to a state offense to mirror the federal offense of being in the country illegally, I think we would lose on a constitutional challenge for a detention right now just for the purpose of immigration status verification. There might be some other committee members here that could provide a little more insight, but that this is one of those changes that were made clear, contemplating a facial challenge of the provisions of the bill, and I think it was a necessary change.
And Mr. Chairman, I'll simply offer to the author. I strongly support the prospect that we're protecting people's privacy, and we're not detaining people on reasonable suspicion of immigration status. I think the underlying probable cause of another offense is a very important threshold for the purpose of initially detaining somebody. But if in the due course of that detention, whether it's 24 hours in a local jail, whether it's in a 10-minute, 15-minute traffic stop, if the threshold for an underlying immigration status situation rises to probable cause, not reasonable suspicion, but probable cause, I would ask the author to consider. It seems in keeping with what we're doing here, and I think certainly my policy objectives, that if it raises to probable cause, then that could be an underlying reason for law enforcement to perhaps pursue that in itself.
And to the chairman, I from a policy philosophical standpoint, I think you and I are exactly on the same page in terms of our underlying goal here. I think that change was necessary from a pure constitutional standpoint in order to make sure that we hold up. I'll commit to continuing to research the issue, and we can talk about it over the next few days as we draft the committee sub. But I want to make sure we're on as sound a footing as possible. And this is a provision. We're spending a lot of time talking about this provision. There's going to be some changes before the next committee sub. I think that are going to make certain, or as certain as possible, that we're not putting our law enforcement officers in a position, an untenable position.
Mr. Pack.
Representative Ramsey, although I also agree with Representative Setzler and yourself, the policy consideration beyond that, but isn't it true that if you were to create a state crime for being an illegal alien, that is pretty clear from the precedent so far that that's preempted by federal law, and as a result, it's very hard to legislate around that rule?
I think it's that goes to the heart of why we remove the independent ability to detain an individual beyond the context of an existing criminal investigation.
To put a finer point on an exchange you and I had before, I think I misunderstood a point you were making in terms of the detention and the time period, and I'd thrown out the 48-hour. That, of course, is subsequent to arrest.
Right.
And
exactly
as
right.
opposed to the investigative stage prior to arrest, which is simply a reasonable time period at this point. And I want to thank Mr. Pack for straightening out what I thought I heard but I didn't hear. So, a quick one.
A factual question: Is law enforcement today, if a local or state law enforcement officer detains somebody and has probable cause they're committing another federal crime, is that not in itself cause to detain somebody? I don't know. I mean, you could outline some other federal crimes, but in my mind, it would seem if there's an understanding of another underlying federal crime, that local law enforcement would be able to, in the natural course of what they do, detain someone for that. And is this not that exact same circumstance?
Oh, well, that's one of those questions I'm going to have to just get back to you on, if that's okay.
Because that was submitted
and take a look at it. But I think we need to. My understanding is that we would need to expressly authorize enforcement in that context. And in this, from a status standpoint, an immigration status standpoint, I think from a constitutional standpoint, I'm not sure we can get around precedent that's out there right now. But again, this is an issue I want to work. I want the strongest bill possible that I'm confident, and to the committee's confident that it's going to withstand court scrutiny. And I'm committed to working with you on this point and other points to make sure that happens.
Mr. Coomer.
Thank you, Mr. Chairman. Excuse me. I think we're having a little confusion about, and I think you started the clarification of an investigative detention versus a probable cause arrest, and we're kind of throwing reasonable suspicion and probable cause interchangeably, but they're not really interchangeable terms. They're two different concepts. And the point being that, and I think the rule that we're setting out in this statute would be that, first of all, there is no primary offense of illegal status under state law, and we're not creating that as a crime. So you would not be detaining anyone for the specific purpose of determining their status. That's not a legitimate reason to detain someone. You could detain them because they are suspected. There's a reasonable suspicion that they've committed some other underlying offense, whether it be an expired tag or DUI or whatever it is. You then have a reasonable suspicion to detain them on that primary offense. And as I understand it, the statute would allow or authorize at that point the law enforcement officer to check the status at the same time they're doing their typical investigative detention, but we're not allowing the officer to keep the person on the side of the road or otherwise detained solely for the purpose of continuing the immigration status check. Once the the primary offense investigative detention has expired, you got to let them go. Now, that doesn't mean, as you've stated earlier, you can't stop. You don't have to stop the inquiry. You just can't keep them present to continue the inquiry. And I think, to Mr. Setzler's point, the real issue is we're not creating a state crime of illegal immigration status in the state of Georgia. Therefore, we don't have a reason to stop somebody and investigate them for that particular federal offense. Does that comment help?
That is very well put.
Thanks.
Ms. Neal.
Thank you, Mr. Chairman. And I just had this thought as far as how it would play out, but could it be necessary to add a piece to where, to protect officers from any of these issues, if a person is going to, say for instance on a traffic stop, if they're going to possibly be arrested anyway for the charge of no license, could that automatically give the officers reason to do a citizenship check based on the offense of no license?
Well, in the committee sub that we're working on, we're going to hopefully kind of go in. I think your point is giving more concrete guidance,
right?
And and less, I guess, less vagary in how the
right.
process works. And I think the committee sub's going to that the reworking we're working on right now is going to, I think, address that point. So I think that's if you could hold that thought and that question until whenever we get that committee sub, hopefully by Tuesday, or certainly before markup of the bill, we're trying to, as much as possible in the context of this provision, make sure there's concrete guidance on the scenarios where verification process can occur.
Okay.
To make an attempt to address that point, I mean, as a practical matter, when an officer stops an individual and there is no license, there's an arrest.
There's an arrest.
And so that's what begins the process. And from a practical standpoint, my sense is that about 90-something% of this process, if and when it occurs, will
right.
begin with a traffic stop and more than likely be a no license situation.
Right, and subsequent section of the bill, we expand in the arrest context. You know, we're talking about the investigative context right now, but in the arrest context of the no license, a person is brought into jail and arrested. We're expanding the verification process beyond current law to include all misdemeanor offenses as well. So that would happen in the jail context.
Okay.
And just to be clear, I mean, that arrest occurs regardless of any other circumstance.
Right.
That, you know,
Right.
you're driving without a license, Mr. Ramsey, you're going to spend some time at your
Right.
local hotel as well. So,
right.
yeah, okay, as would I. All right, any other questions on Section 8?
All right.
Seeing none.
Section 9 is a it's language that is it's aimed at ensuring and stating our intention as a General Assembly to encourage all law enforcement officials in Georgia to work with federal immigration authorities and utilize the resources made available to them by the federal government. Now, this is an area where I would love to say that we have the resources to create a grant or a resource center to help localities avail themselves of resources, federal programs and the federal programs and grants that are in place, but unfortunately we don't have that money to plug in. So what we've done here is we've made very clear that we're encouraging state and local law enforcement agencies to enter into agreements with the federal government where applicable. 287G is the program is the obvious example. We're making very clear that our state law enforcement officers, state and local law enforcement officers, are authorized to carry out provisions of immigration law federal immigration law when expressly permitted by the federal government. I think we need to. I think there's a little bit of a disagreement as to whether that is an implicitly held power by law enforcement. But here we clearly say that if there's a program or procedure in place that is authorized by federal authorities to arrest illegal aliens, to transport illegal aliens, we're making clear that we as a state are sanctioning your participation as part of those processes, our state and local law enforcement officers. So, when we're also again making clear that we're encouraging state and local government to take advantage of all available federal resources out there. So, with that, I'd be happy to take any questions or move on to Section 10.
Questions on Section 9? Seeing none.
Section 10, the Department of Public Safety, in 2006, we passed a law requiring the Commissioner of the Department of Public Safety designate peace officers to be trained as part of a federal memorandum of understanding in federal immigration law. I can't remember the number, but I think it was 11 or 12 that were trained initially, and through attrition those numbers have now gone down, and we didn't put an obligation to annually designate peace officers to go and to be designated to go and get this training. Now, I'm very, very, very sensitive to the resource burden our Department of Public Safety is under, and certainly would entertain and appreciate the opportunity to hear the Commissioner's thoughts on this, and we'll certainly speak to him in the days ahead. But I think the purpose of this is to make sure the intent of the General Assembly in 2006 which was to make sure that we always had a group of state law enforcement officers trained in federal immigration law through the as designated by that commissioner, that intent is carried out by making sure that we're annually designating officers to receive that training. I think it's important to make sure that that intent that we put in place in 2006 is carried out. So, and again, as to the annual number that's required, that's something I'm certainly open and willing to hear comments and concerns from members of this committee and certainly our friends over at the Department of Public Safety. So with that, I'm happy to go to Section 11, and unless there's any questions on Section 10. Section 11 this is again another one of those. In a perfect world, I would love to have resources where we could mandate the creation of an incentive program or grant program for local law enforcement agencies to participate in federal programs such as the Homeland Security or the 287G program. And a lot of entities have applied for 287G, and that's really out of our hands when the application is considered by the federal government. But beyond that, I think it's a good policy to start thinking about, and hopefully we can. Right now, this is all subject to available funding, and hopefully someday soon we return to an era where we could actually plug money into the budget for worthy initiatives such as this. But what this does is it provides, subject to available funding. We're setting out the parameters where a grant or incentive-based program could be set up for local law enforcement officers, for the agencies, for the purpose of helping them to access and make use of available federal resources with respect to federal immigration law. So again, it's only subject to available funding because we all recognize the resource situation we're in and the budget situation we're in, and I'll be happy to answer any questions on that point, or I can move on to Section 12.
No questions.
This is I've mentioned this a number of times in the context of discussing previous sections. This is where we expand the existing requirement that when an individual is a foreign national is charged with a felony, that there be a verification. And it's important to understand why this exists. Every foreign national, pursuant to Article 36 of the Vienna Convention, is entitled to notification that they can seek assistance from their consul. And there are numerous cases across the country where convictions have been challenged where a foreign national, citizen of another country, was not given that notification, and there have been mostly unsuccessful challenges to overturn those convictions. In fact, the Department of State every year puts out a document this thick. It's called Consular Notification and Access, and it's instructions for federal, state, and local law enforcement and other officials regarding foreign nationals in the United States. And it very clearly states, because of our participation in this treaty, that we have to give notice to foreign nationals that are detained of their right to seek contact with their consulate. And in fact, some countries, we actually have not just a notification that you have a right to do that, but some signatories to the treaty, you are actually required, even if they don't want you to contact the consulate, you have an obligation to notify that foreign national's country's consulate. What we're doing here, I think, is expanding it from not just the felony context, but to the misdemeanor context as well in an arrest in an arrest setting. And I think it's an important expansion. I mean, to the extent that we're detaining arresting an individual on a misdemeanor, whatever it is, and we're not ascertaining their immigration status for the purpose of notifying their consulate, I think we're potentially jeopardizing convictions, and I think this is an important piece of the bill. Happy to move on to Section 13 or answer any questions on this point.
Just to be clear, Mr. Ramsey, in terms of, to your knowledge, does such change, is that consistent with existing federal law or federal regulation, to your knowledge?
I don't think it in any way runs afoul of any federal provision.
Okay. Any other questions on Section 12?
Section 13 is, again, I keep beating a dead horse on how resource deprived we are as a state, but this is again another one of those. Hopefully, when the budget picture improves, we'll be able to make this not just subject to an appropriation of funds, but something that counties can count on. But this provides an additional pot of money subject to appropriation, which means it's let's be honest here, it's probably not going to happen in the short term. But subject to an appropriation, we're going to provide a 10% addition in terms of the reimbursement rate for the confinement of state inmates for those that demonstrate a continuous either participation in 287G or an attempt to participate in 287G. So if you've made your application and you can demonstrate that you've done that and you're trying to gain access to that program, and I think we're going to hear hopefully from we have 4 counties that are participating in 287G just how incredible the results from their sheriff's department's perspective of their participation in 287G, what it's meant in their community in terms of addressing issues posed by illegal aliens in the criminal context in those communities. But this is, again, one of those things that we'd really like to do, make it something that can be counted on once the budget picture improves. But for now, it would be subject to an appropriation of funds. And this is, again, one of those things just to encourage our law enforcement officials to take advantage of a program out there that has a demonstrated record of success. No questions. I can move on to section.
I think we had maybe spoken about this a while ago, the continued use or attempted use. Maybe we could look at potential language. I'd be hesitant to have a jurisdiction, have a straw man attempt, and then have these proceeds go.
No, I think that's a fair point. We want to make sure that they are applying pursuant to the terms of the program on an annual basis. That's really what we're trying to get at. So I think we can certainly take a look at that. And I'll make a note to do so.
Ms. Neal.
Thank you, Mr. Chairman. If you can clarify this section for me, am I to understand that, like, say, for instance, most of the sheriff's departments or what have you, it starts probably on the low end $40 to $80 a day to house an inmate. Are they going to be getting the minimum amount, or are they going to be getting the actual cost?
All this whatever we are paying to counties for the incarceration of state inmates, whatever that rate is, this will provide for the counties that are either enrolled in or attempting to enroll in through an application process in the 287G program an additional 10% bump on that reimbursement rate on top of what what is being paid to counties around the state. And again, this is one of those things that we're making it subject to the appropriation of funds, which means, in this era of cutting billions of dollars at a time, it's probably not going to be appropriated in the short term. But I think it's important to put the mechanism in place.
Just so for clarification, at the start of this, if it were to ever move forward, the sheriff's departments would not be getting the maximum amount that they're spending on the.
No, every county gets paid whatever the reimbursement rate for housing a state inmate is at that time.
Okay.
What this provision would say is whatever that amount is, if you're a county that is enrolled in or attempting to enroll in E-Verify, you'd get paid an additional 10% on top of what.
Okay, I got you. I got it.
No further questions.
Section 14. This is the much talked about E-Verify requirement. There's a number of states have done this. I think it's 6 now, and a number of states are proposing to do it as we speak. And this is at the outset of my comments. I talked about the incentives that exist for people that are in this country illegally to come to the state of Georgia, and obviously, one of the biggest, if not the biggest, is the ability to gain employment. What this provision does is an attempt to get at that, as using the existing tools that are available to us as state policymakers. And the very best tool that exists right now in the employment context that's available to us in terms of ensuring jobs are only being obtained by those that are legally eligible to work by federal law and legally in this country is the use of the E-Verify program. What this will require is that at the point before any county or municipal corporation issues a business license, an occupational tax certificate, or any other certificate or license required to operate a business in that jurisdiction, they're going to have to provide an affidavit that swears they are participating in the E-Verify program and provides the enrollment number that you receive when you enroll in E-Verify, and that's a requirement at application and at any renewal thereof. We have a phase-in period based on the number of employers for the requirement. We want to make sure there's plenty of advance notice. and that we're giving businesses an opportunity to get into compliance with this section. You will see for 500 or more employees, companies, it's September 1st of this year. 100 or more, it's January 1st of 2012, and 5 or more, July 1st, 2012. And we do provide. Every state that's done this has provided some kind of exemption for the smallest of small businesses. And the number's different depending on the state, and then that's kind of a policy decision that we as a body have to make. What's the appropriate number? Looking at a cross section of what other states have done, we've put an exclusion for employers that have fewer than 5 employees. We want to make sure we're not putting an undue burden on what are truly the kind of the mom and pop businesses in our state. I think that this is the very best tool available to us as state policymakers, is the use of E-Verify. I've enrolled my business in E-Verify. It took me about 23 minutes from beginning to end to go through the enrollment and application process. And those of you that know me know I'm a techno idiot when it comes to using computers. And the fact that I could do it so quickly and easily, I think, is evidence that we're not talking about an undue burden here. The process we go through, the process you go through of actually seeking verification, and I think that's a point that needs to be made. When you register for E-Verify, you sign a contract with the federal government, a memorandum of understanding, and that prescribes how E-Verify can be used. If you deviate from that, the terms of use that you sign, then you risk expulsion from the program. A couple of examples. You cannot use E-Verify to pre-screen employee applicants. You can only use it after they are employed by you. There is also there's a lot of talk about well you have false nonconformances that are coming back. Built into E-Verify, if I hire a new employee tomorrow and I send off their identification, their information for verification, it comes back as what's called a tentative nonconformance. I can't act on that. I would be violating the terms of my contract with the program. They have to be given an opportunity. You have to call the employee in and give them an opportunity to tell them here's which agency raised a red flag, Department of Homeland Security, Social Security Administration, and they have a time period to go to that agency and prove to them that they are eligible to work in the United States. So there are strong inherent in the program. There is a strong kind of appeals process for an individual that has been found to be ineligible to work, but believes and has evidence that can back up the fact that they are in fact eligible to work. So I'm happy to take any questions, and I think this is, if you put a gun to my head and said what's the most important piece of this bill, I would say this section is. I think the incentive. We have more illegal aliens in Georgia than they have in Arizona. Arizona shares a border. We have a different reason that people enter into our state illegally, and it's jobs. That's been driving this for decades, and particularly in this time when so many of our constituents are struggling to make ends meet and feed their families. I just think it's absolutely critical that we make sure those job opportunities that are out there are reserved for folks that are eligible by federal law to work in this country.
Mr. Sessler.
Thank you, Mr. Chairman. To the author, I wanted to raise an issue that might improve Section 14. As I talk to small business owners in my district, which is a very middle-class district up in North Cobb County, talk to folks like painting contractors and small general construction contractors that have been kind of making do with renovation work and on a much smaller top line than they've had gotten used to through the early part of the decade. And you talk to them about the marketplace. There is a concern out there about sort of the unfair labor practice of some contractors employing illegal workers versus other contractors that are trying to give folks a chance. Many of these people that are working for the legal contractors are in this country legally. They're hardworking people. They're here for all the right reasons, and they're playing by the rules. My concern is as you look kind of deep down into that's just one industry. But again, construction, paint, those kinds of things. are areas that, if you look around the state, do have a noticeable number of illegals working in there. There's certainly pressure on those contractors. My concern is with the less than 5 employee companies. You've got these companies, these micro businesses, if you will, are still having to file, to get a business license. As you've said before, you encouraged this committee to go on and look at the E-Verify system and see how easy it is. I actually went on and took the little tutorial, and it's almost trivial. It's very simple: name, social, birth date, and in a matter of seconds you have an answer back. I'm concerned that perhaps if we limit it to only companies with 5 or more employees, that there's an ability, as we see in the marketplace, to have these small contractors to employ 3 or 4 people, and to be able to sidestep I think the great protections that you've outlined that E-Verify provides. I don't see it as an undue burden. If you're going to employ 3 or 4 people and benefit from that as a business owner, I don't think the burden of E-Verify is too burdensome. And I don't know that there's a great distinction to me of someone that employs 3 or 4 employees to someone that employs 6 or 8 employees. And I think what we've done here is in taking the strong action that Section 14 would do, we would simply provide an incentive to break down the LLCs and the S-Corps to being 3 or 4 employees, to provide a way for illegals to kind of fly under the radar potentially, and bad actors to benefit in this tough economy that's hard enough on our good business owners.
Well, to your point, I think you're exactly right on several points. One, we do want to protect and make sure we're protecting those good actors out there that are trying their best and aren't looking the other way. They want to employ labor that is here in this country legally. We heard from during the committee hearing process, we heard from a several generation framing contractor that had to shut his business down because he just couldn't compete with the black market labor anymore. He refused to do it himself. And those are the kind of people we need to protect, not just with this section, but with this bill and through every means available to us as state policymakers. Regarding the number, this is in its purest form a policy call. I mean, there is no constitutional grounds that it needs to be 5 or 3 or 10 or 15. This is an effort. I looked at what other states have done. I think there is, and I agree that this is not a hard process to enroll in. But I think the other states that have done this have in an effort to make sure that the true mom and pop, that just 1 or 2 employees, 2 or 3 employees, that may not even have access to a computer. We're not unduly burdening them, and I think it also is a decision based on looking at what industries are the most egregious, obvious violators. Make sure we're capturing those industries while also not unduly burdening those really small mom and pops. All that being said, I'm a corporate attorney by trade. It's very easy to set up an LLC and multiple LLCs and operate your business in that manner. And there is certainly that would probably those that are looking for a way to get around the law would certainly create an opportunity for them to do so in that way. In terms of the number, though, I think that's one that we should just think about, debate as a committee, and then on the floor, and then in the Senate, and see what we think is appropriate. But I thought 5 was a good number based on what other states have done, but certainly am all ears and not wedded to that in any way.
Did other states, if I could just ask, did other states that you saw that you studied, did they take the 5 and then add in any statutory safeguards to guard against the splitting up scenario?
I don't know how you could do that.
I don't know either.
But this is a unique mechanism that we've put in here. I mean, other states have said it is a state requirement that you enroll in E-Verify. But there's but the compliance with those provisions in those other states have not been have been very, very low because there's not an enforcement mechanism. What this is an attempt to find a point at which we can ensure a much higher rate of compliance with the law, which is at the point of issuance of your occupational tax certificate or your business license. It's called different things. And we're still looking. This is still an evolving section because we know every jurisdiction doesn't issue something called a business license or an occupational tax certificate. So we're attempting to continue to make sure we get as much statewide coverage on this as possible, and that's why we've added terms. We have business license, occupational tax certificate in the occupational tax certificate in the committee. So we've said, or any other certificate or license necessary to do business in that jurisdiction. And we're going to. I suspect this is a provision that will also be subject to some wordsmithing before the next committee sub to make sure we get as much coverage and participation in this law as possible. Because other states, the experience has been by simply making it a state requirement, and there's no money to go out there and audit and do enforcement. It's not being complied with near to the degree that the policymakers in those states want it to be. This is an attempt that is to make sure we give an annual point of contact with a business where we know we have an opportunity to make sure they're enrolled and participating in the program.
Did you have a follow-up, Mr. Sessler?
Only, Mr. Chairman, only to say just again, I think when you consider the sophistication of running a small business today, withholding Social Security, the other things you have to do to be an employer. I don't know that it doesn't show the E-Verify process to not be trivial by comparison, and we can explore this in future committee meetings, Mr. Chairman. But I would like to revisit the number.
Mr. Coomer.
I just wanted to follow on with what Mr. Setzler was saying. We look at the broad swath of all the federal and state regulations, legislation that have to do with employment and labor law, and you find cutoffs at 50, 15, 10, 5 here. I think the lowest cutoff point I'm aware of is in workers' compensation, and I don't remember if it's 1 or 2 employees, but it's a very low number that the employer has to comply with.
Our resident contracting expert is holding up the number 3 behind you.
Okay, it's very small number, and I would just go on the record as saying, as an employer of 2 employees, I don't think it's too much of a burden to ask me to participate in this program and to comply. So I would just second Mr. Setzler's concept.
Well, I think those are very, very, very good points, and certainly at amendment time, it's something I'm sure we'll take a look at.
Ms. Benfield.
Thank you, and let me apologize for having to leave for a good part of the hearing. I had another commitment and I had to attend to. I have a question about page 15, subsection G, regarding the Attorney General charged with enforcement. I'm just curious why the AG and not, it looks like it's a misdemeanor offense, it wouldn't be the local solicitor. And my follow-up is whether the AG's office has been consulted about this.
Well, I don't think we need to expressly put in that for any criminal offense that we need to say that the district attorney or solicitor can bring an action. I think that's just implicit. I mean, we can add it, but I don't. Terry, am I? Yeah, you don't. It's not necessary to put in there. I think this is just adding an additional party, expressly providing the AG. And I don't intend them to be the exclusive party authorized to bring these claims. And if we need to put district attorney, solicitor in there, I don't think we do, though. I think it's just implicit that they can bring a criminal violation. But I wanted to give the opportunity to the Attorney General if a citizen or a group of citizens or they have reason to believe that this provision is being systematically ignored, they have the opportunity to look into it and bring a claim.
Okay. With regard to the former issue, maybe it's just me. It seemed misleading when you specifically put in the AG that they would be the sole enforcement provision. But
I don't think anything I said or anything this bill says they're the sole. It just says they're authorized.
In addition, but with regard to the AG's office, I just know in years past that we have presented bills in this committee and the Civil Committee where the AG is given authority to do certain things, and then I'll call the AG's office, and they'll say, "I didn't know that was in the bill," and you can put it in there, but we don't have the funding and we have no intention of actually doing it. So my follow-up question is whether the AG's office has been consulted and whether or not they even have in their budget funding to pursue this.
I haven't. I have not consulted the AG's office on this point, which is why I think I wouldn't presume to put them as the sole entity that is authorized to bring one of these charges. I do think it's a good policy decision to authorize them to do so, but certainly our local prosecutors are going to be authorized to bring these as well.
Just one brief follow-up. I think it's a courtesy to them to find out, what their position is, and it is helpful to know if they would in fact be pursuing any of these cases. I think it was the zoning bill that we dealt with last year, or it may have been a few sessions ago. They're all merging together, but there was a provision for the AG's office to come in and enforce zoning violations if they got to a certain level. And I checked with the Attorney General's office, and they said, well, you can put it in there, but we have no intention of ever pursuing these claims. So it's just helpful to know if they're actually going to be looking at these cases.
I would take notice of the fact we have a different Attorney General now.
Yeah. Oh, I understand that. I understand, but the budget is probably
just an observation.
A deciding factor in some of these issues.
Mrs. Cooper.
Representative Ramsey, I have a major concern expressed by our chamber and other chambers across the state with possibility of setting up the possibility, as I said before, of lots of lawsuits against our counties and our cities and our state. And I wonder if, and I agree with you, that people come to the state because they want jobs, would not the strengthening of this part of the law basically take care of 95% of your problems? If businesses have to verify before they can get their business license that they're not hiring illegals, I truly believe that this would probably cut off the jobs for people, therefore they would not be wanting to come. And could we possibly get by with perhaps not setting up the possibility of lawsuits against our counties and cities?
I agree with you that this is the most important section of the bill. But I also believe we cannot go through this process without at the end of it, without a enforcement mechanism in place, which is the private rights of action is what you're referring to previously in the bill.
Right.
Without walking out of here in our bill with a mechanism by which those three specific sections of the law, most importantly though the requirement to use SAVE for the dispensation of public benefits and E-Verify in the public works contract setting, we have to walk out of here with a real enforcement mechanism to make sure that's complied with. As I said earlier, I'm continuing to work with groups and members of this committee to figure out what the right enforcement mechanism is, but in the SAVE context and in the Public Works E-Verify context, which you were here when it was passed in 2006, I was not. It's an important provision, and we need to make sure it's carried out the way it was intended by you and other members of the General Assembly when that law was passed.
Well, I mean, having seen counties and cities and how much they need their tax revenues, I truly believe that you would get your enforcement mechanisms if the companies had to do that. But I'm really concerned about setting up for not the real lawsuits, but the frivolous lawsuits that could be brought by just anybody.
And I spoke a great deal about that earlier.
I'm sorry,
Chairman. No, and I agree with you. I totally agree with you, and we're going to look at ways we can make sure that our cities and counties aren't burdened with frivolous lawsuits.
Thank you.
So.
Mr. Peck.
Thank you, Mr. Chairman. Representative Ramsey, a couple things. Since it's already illegal to hire an illegal alien for your business, I could conceivably, under federal law,
right.
I could conceivably see, for example, like tax fraud, because you're obviously not reporting income or not reporting certain FICA taxes and things like that. And I believe that's a felony if you file a fraudulent tax return. And I realize, in looking at the proposal here, that submitting a false affidavit in, concerning whether or not you participate in E-Verify is is somewhat similar, if not less, than what's already prohibited. The question is, I don't have any judgment one way or the other. The question is, if there's already a felony trying to deter this conduct, and we still have this problem, the question is whether or not the provision that you've drafted is going to work or have an intended consequences of what we want. Secondly, if I may, Mr. Chairman, I think a similar type of law was passed in 2007 by Arizona, and I think it just got argued this year in the Supreme Court. I'm wondering what the difference are, and I haven't looked in very closely between the proposal here and what's been adopted by in Arizona in 2007, and I believe the case is Whiting.
It is, and you're right that we're waiting on a ruling right now, and I don't think the difference in, the way the system we've set up is significantly different than what they did, but I don't think it really matters in that I think the fundamental question is, does the state have the authority to mandate the use of E-Verify? So I think if the court ultimately sides with the United States Chamber of Commerce in that case against the state, then I think this section is moot. I'm hopeful that in reading the tea leaves, I feel guardedly optimistic that based on the disposition of the court that the lower court rulings that have already said that sided with the state are going to ultimately win out. But in terms of the difference between how we have it set up versus Arizona in the context of that legal challenge, I don't think it really matters. I think the question is, can a state mandate the use of E-Verify? Your other, what was your? I'm sorry. I got.
The question is, given the scheme that we have now, statutory penalty scheme, and it seems to not have worked in deterring illegal immigration and also employment of those individuals.
Well, I think there is a very, very, very dramatic difference between a system where we're requiring private employers to enroll and participate in E-Verify versus what would be a prosecution for false swearing in the context of a tax of submission of a tax document. I think that was your example.
I think my point is not the actual structure of it, but if the penalties are I guess perceived to be too low.
I'm sorry. No. I mean, the penalty is the mechanism that forces in compliance is you're not going to get your license or certificate if you can't provide an affidavit swearing that you're enrolled in the program.
Right.
How the program is used is determined by the federal government through the E-Verify through your memorandum of understanding, and you have to provide that number that you have enrolled. I think doing it at the point of issuing your license or certificate is the best thing that we've come up with.
Would be a greater disincentive than what's the criminal penalties that we have now? Is that?
Well, I think your inability to get your certificate or license to do business, I think that's kind of a threshold you've got to meet to run your business. So. That being said, though, right now, if you swear a false affidavit, you're subjecting yourself to a felony false swearing prosecution. If members of the committee think we need to look at beefing that up a little bit for people that try to circumvent this requirement, I think we're certainly. We'll look at that.
My point wasn't to make that, but my question is, if the penalty as it exists, or which is penalty similar to what you have proposed, if it's not working, perhaps we should look at an alternative.
Well, I think the penalty is the most important part. That is much less important, in my opinion, in terms of forcing compliance than the penalty of not being able to get your license or certificate necessary to do business. So.
Ms. Neal.
Thank you, Mr. Chairman. This is actually going to kind of be progressive, starting from earlier, but it ends with the E-Verify. I'm not sure if it's beyond the scope of what we're addressing at the moment, but as far as the E-Verify is concerned, will it be interconnected with other government agencies? As mentioned, like in earlier sections, like 3, we were talking about agencies being prone to get lawsuits for not abiding by the whatever, like we set in place for as far as the bill is concerned. How does that relate to E-Verify as far as it all being interconnected with the government agencies? Like, for instance, is this bill extending to the point of, as far as Section 3, where the areas such as people getting public assistance being leaked in with the E-Verify, and then also when it comes to businesses using E-Verify for jobs, does that all interconnect so that one can see the other? Does that make sense?
I'm sorry, I'm not 100% getting your question. I mean, E-Verify, the SAVE database, the SAVE program, which is confirming eligibility for to be a recipient of public benefits, is a different system than E-Verify. E-Verify can only be used in the employment context. Okay. Verifying your eligibility to work based on federal law.
Okay, so it's a separate system.
Yes.
Okay. Okay. Thank you.
Mr. Coomer will have the last question before we break, and we'll come back at 1 o'clock and get to Section 16 at that time. Mr. Coomer.
Thank you, Mr. Chairman. It's kind of a technical issue, but it occurs to me there may be a problem if you have to. I heard somebody else explain that you have to hire a person before you can check them through the E-Verify program. But you'd have to E-Verify before you can get your license to do business. So you may have a problem getting your license to do business if you can't. If you can't, you might have a chicken and egg problem.
The affidavit will require you to swear that you are enrolled in the E-Verify program. That's it.
Okay.
And that's all we really can do. We can't tell you how you use E-Verify as a state. That's prescribed by federal law, and it's governed by the contract that I sign, and if you enroll your business in it, that you will sign the memorandum of understanding saying here are the terms of use and here's how you can use it. So the affidavit will merely require that you swear that you're enrolled and provide your user identification number.
Thank you.
All right, we'll stand in recess until 1 o'clock. Representative Ramsey, I think we were at Section 15. Is that right?
Yes, Mr. Chairman. Am I on?
You are now.
Yes, Mr. Chairman, and I should be able to very, very quickly conclude my run through the bill, and I will speak to Section 15 and 16 together because I think they're related. What we're doing here is there is and a couple of other states have promulgated similar statutes, but what we're trying to do here is definitively provide guidance to state and local government as to what documents are acceptable for acceptance for any official purpose, whether it be in the benefits realm, the identification realm, because there is a real problem of the use of fraudulent and forged documents. We want to make sure documents that are being accepted for official purposes in Georgia by our state and local governments are secure and verifiable. In that regard, we've promulgated Section 15 and 16, and we have asked the Attorney General's office, who right now is obligated under current law to provide annually a list of public benefits in the context of existing state law, and what we would ask them to do in addition to that annually as a result of this legislation would be to provide a list of federally and state issued documents that are secure and verifiable as we set out in here. That's really the intent of Section 15 and 16. I'm happy to answer any questions, but it's pretty straightforward, and I think it's an important measure that's going to make sure that the documents that are being provided for identification or in the context of the dispensation of public benefits that are being provided to our government officials are secure and verifiable, and help our local governments in particular by providing a list of those documents to them on an annual basis to help them in that process as well. So that I'm happy to take any questions, Mr. Chairman.
Mr. Setzler.
Thank you, Mr. Chairman. I just wanted to ask some general questions about how exhaustive this list of in the definition of secure and verifiable document, it lists the matricular consular card and some others. I'm assuming you've done quite a bit of homework on
this is expressly excluding the matricular consular card. I think it needed to be a positive statement in the bill, needed to say that. The FBI has testified to Congress how this is the most easily forged document available on the market today. There's numerous anecdotes of how easy it is for a person to go and get a forged consular card. And the purpose of this is a recognition of that fact, while also saying that if we want to make sure that we're immune to a challenge brought on a preemption ground, that if the federal government in any context mandates that a state accept the matricular card, I'm not aware of one, that we've contemplated that and would accept it if it's mandated by federal law. I think that's important to protect us from a challenge on preemption grounds. But this is a document that shouldn't be used for official purposes in Georgia. It shouldn't be recognized for any official purpose. And there are certainly any person would have access to a more secure and verifiable form of identification if they are in this country legally.
Does this bill in any way, or perhaps should it prohibit local governments in Georgia from creating a government ID card? This is the Kennesaw ID card that we give our citizens, if they're here, to give them a form of government ID. I mean, perhaps local governments, being creative, could create something like this if there was a sentiment that is that something we could consider as sort of limiting our local governments from creating new forms of government ID that aren't being issued today?
So you're concerned that this would prohibit local governments from pursuing that?
No, I want to make sure that local governments aren't able to be creative and do that. To me, there's integrity in our state driver's license.
No, I think by prescribing on an annual basis what documents are acceptable, I think that would prohibit a alternative form of identification in terms of it being recognized by one of our political subdivisions.
And I'm sorry, the construct of this bill so much better than I do. Is that outlined in here? We give a
because we have an obligation.
Attorney General, gotcha.
Right, exactly.
I got you. Okay, thank you.
Sure.
Any further questions from members on sections 15 or 16?
And to conclude, Sections 17, 18, and 19, we have the effective date, and we have a severability clause. Obviously, that's a key component here. If there were to be a court challenge and one provision of the bill was enjoined for any reason, we want to make sure the remaining provisions of the bill go forward. And that's Section 17. Section 18 is the effective date. And Section 19, of course, is the repealer that we put in every bill. And with that, Mr. Chairman, I've concluded my presentation. I truly appreciate the good questions, the interest by the members of the committee and their thoughtful comments. I look forward to this being a fluid process. The bill is by no means etched in stone. In fact, there will in fact be a committee sub, certainly, with some additional revisions by our next hearing, or certainly by when we mark the bill up. I believe this is an important and critical piece of legislation. Our constituents, our taxpayers need relief. We have a solemn duty to them to make sure that the resources that are scarce in these times that they're sending to their state government and their local government are protected and spent efficiently on folks that are here in this country legally. That's the intent of this bill, and I look forward to working with all of you as the process continues to evolve. Thank you, Mr. Chairman.
Thank you, Mr. Ramsey. I committed to members earlier that if there was a question that came up in their minds from a previous section that we weren't actually covering at the time, we can certainly go back and cover that ground, and this would be the time to do it. It's not the exclusive time to do it, but we do have time now. Ms. Byrd.
Thank you, Mr. Chairman. I would like to go back to Article 5 on page 6, where we talk about if someone is moving illegal aliens, and there are less than 7 would be a misdemeanor and more than 8. What happens if someone is caught the first time, it's a misdemeanor, and it's done again and again? Does that then jump to a felony, or what happens there, please?
No, and that's an issue that we've considered. We made the distinction in terms of the number of individuals that are being transported, because we really wanted the most severe penalties focused on on individuals that are kind of doing this for profit. They're transporting a large number on a kind of as part of a systematic commercial enterprise. We have talked about, after the first offense, even in the under, whatever the threshold is, whether it's 8, under 8, making the second and subsequent offense a felony offense, and that's certainly something that I'd be willing to consider and talk about. I think it's again, I hate to beat a dead horse, but that's kind of one of those clear policy decisions we have to make as a committee.
Thank you. And I have the other question was, if someone has a taxi service and they are stopped for a traffic infraction, and they happen to have an illegal alien in their taxi, what happens? Could you explain to me, please?
You would have to prove that taxi driver knew, which is not an easy. I mean, that's a very high bar from a prosecution standpoint. Knew that he was transporting an illegal alien and was committing another crime concurrently therewith.
Very good. Thank you.
Sure.
Mr. Pack.
Representative Ramsey, quick question, I guess, for consideration as you do the committee sub. I could imagine a situation when you have a legitimate traffic stop, and the passenger or passengers in the car are illegal aliens, and then the question becomes to the officer at the time: what is the scope of investigation that he or she is allowed to do at roadside? And I know that wasn't the intent of the bill as it's drafted today, but I could imagine a situation where we might leave out our law enforcement community. I think the proper procedure generally is to ascertain the identities of everybody in the passenger compartments. And I hadn't really thought this through, other than because Representative Byrd did bring this up, that we may have to give additional considerations to those situations, because beyond the actual stop
and
itself.
the intent, remember, we're only going after the transporter, not the transportees. On this offense, we want the person that's knowingly transporting illegal aliens. If you think there are kind of procedural things we need to do to give better guidance or more concrete guidance to our law enforcement officers out there on the front line, then I'm certainly would entertain that and look forward to working with you on it.
I'd like to follow up on that, because I think it's something that you and I may have discussed at one point, where in the real world example of the traffic stop, which I think this is all nearly always begins with, or it will as a practical consideration, and you've got 3 or 4 people in the vehicle. I guess my first question, just from a pure legal standard right now, is, of course, they're asking for an identification of the driver. The other people in the vehicle are sitting there quietly. They have not done anything wrong. The officer has no suspicion whatsoever that they've done anything wrong. They are simply sitting there quietly doing nothing. The officer, there's no license. They, depending on what is passed here and what standards we already have in place legally, ascertains at the time that the driver possibly is not here legally, may have a thought in the back of his or her mind that the people in the vehicle are not as well. I guess my first question, and necessarily for you, but for anybody at the table who can answer the question, is what is the officer's ability right now is there any limitation on his or her ability to ascertain any information from the passengers at all at that point in time, practically speaking?
Well, are we talking about whether there's a probable cause or reasonable suspicion to investigate a criminal violation?
Well, no, because the passengers haven't done anything. They're just sitting there. There's no license. That person's now in the back of the Cobb County Police vehicle. At that point, what does the officer have the ability to do if he wants, somebody has to drive the vehicle? I guess as a practical, just thinking out loud dangerously as I talk to you, as a practical consideration, he's going to ask someone in the car, I would presume, can any one of you drive the vehicle wherever you're going?
Right.
Or if you want to follow to whatever he or she might say. At that point, I assume someone in the vehicle is going to answer or not answer.
Right.
Right?
Right.
And I guess at that point, that officer then can, if someone says, yes, I can, then he or she can go ahead and validate that individual has the ability to drive legally that vehicle back to wherever they're going. And then whatever facts should come out in the normal course of that conversation, he or she can act upon those.
Right, but that wouldn't be a criminal investigation.
No, but by the same token,
but I think I think the process you described is practically how it. I'm sure Representative Neal could speak to this as somebody out there on the front lines, but that's probably practically how it plays out.
Right. I mean,
but in terms of triggering the citizenship or the immigration status verification, that has to be in the context of a criminal investigation.
Right. And I think going back to Ms. Bird's question about, or I think it was Mr. Pack's question about, what happens with the vehicle or with the individuals in the vehicle, at that point, just organically, I assume, the officer is going to ask who can drive this vehicle. He or she's going to get a response from within the vehicle or not get a response. If someone says, yes, I can drive, presumably the officer at that point is going to ask, may I see your license?
Right.
And which they will produce or not produce. And then whatever.
Well, if they can't produce it, then obviously they wouldn't be legally authorized to get in the front seat and drive the car off.
Right. And so I think at that point, just to put a finer point on the practical considerations of the passenger question, and just for our general edification here, the officer at that point will ask the questions necessary to determine whether or not, and I think organically, we'll find out one way or another if someone here is potentially, if there's another person licensed in the vehicle, and if they're not, then no one's driving.
Well, no one's driving, and if they did, if the officer goes back to his car and sees one of them jump in the seat and drive off, even though he just ascertained they don't have a driver's license, he could then pull that person over and investigate. And clearly, he'd have probable cause that somebody's committing a crime driving without a license, and then the whole process starts over again.
Right. Good. I just wanted to make sure that we're generally clear for those who we're not looking at this through a vacuum.
Right.
We're looking at it in terms of practical considerations as to what's really going to happen in the real world. We've said this in this room 1,000 times. That which is on paper does not necessarily match up with what goes on in the street. Right. And we do well to go ahead and match it up.
Our very, very best in working with our friends in the law enforcement community to make sure those practical considerations are included in the bill.
Thank you. Ms. Neal.
And piggybacking off of what the chairman said, thank you. I can begin by saying and just confirming, once the traffic stop is made and that's established that the person is arrested, we can ask who can drive the car, and then at that time that person can produce whatever necessary ID they have. At the same time, if no one else in the car has done anything, it's one of those unfortunate circumstances in police work where you got to let them go. But because it's not criminalized, we have to let them go. Now, if it was criminalized, like we were speaking about earlier, then of course that would be a charge, and the determining charge prior to that would be the original stop that got the original driver arrested. But I'll probably offer an option of towing the car, probably having the family member come pick the car up. But aside from that, if they didn't do anything else in that car, we gotta let them go.
Right.
Yeah.
No one is suggesting, just to make sure we're all clear, that you can extend to the passengers in there if they're just sitting there doing nothing, just to be clear about that. Mr. Atwood.
Thank you, Mr. Chairman. Just to add one additional thing, a police officer always has a right to make a consensual inquiry.
Sure.
And you're free to leave, but you can always ask. They have the option to say no, but you certainly have that right as a police officer.
Any further questions for Mr. Ramsey? Mr. Setzler.
Hey, Mr. Chairman. I know when we come back on Tuesday, we're going to really be focusing on public comments. I want to again get a little bit better understanding of some of the in Article 5, Section 7. There had been some discussion before about the two offenses: the person acting in violation of another criminal offense, and then the concealment and the transportation or harboring or otherwise. I just felt like this is as good of a time as any, I guess, for the purpose of the whole committee. I'm on page, make sure I'm working on the right version. I'm on line 198. Dealing with concealing, harboring, and shielding. I am going to ask a sort of a follow-on question about, again, those two offenses working together. But concealing, shielding from detection, does the from detection narrow the circumstances down from otherwise harboring or concealing? I mean, I shared the example before of someone having, say, two men and a woman in their home that they knew were illegal. Is that harboring them from detection, or is the from detection an element that requires there to be some?
The detection is, I mean, that shields an illegal alien from detection is independent of harbors or conceals.
Correct.
Grammatically, the way
Right.
it's, I mean, and it's any one of those three independent activities could be prosecuted.
But from detection, if you said, if the sentence was who conceals, harbors, or shields an illegal alien in any place in the state, would that be different than from detection? Is there a requirement there to be that they're being searched for? Is there a requirement that they're actively evading? I mean, I'm just trying to understand. And this is certainly going to be scrutinized pretty heavily.
Sure. I mean, I think shielding an illegal alien from detection is different than harboring an illegal alien. I think harbor. In fact, we put a definition of harboring in there. That these are all federal statutes, and there's each circuit has kind of a different way they've applied this law. I went through the various circuits that have put for instance, harboring. What does harboring mean? How they construe harboring. And I put in here what I think to be the most commonly used definition. This is I think from a Second Circuit case, but it seems to be a pretty consistent definition that courts have applied. And I think, but each of those are independently, those activities could be prosecuted, and they're different from each other. I think harboring is a different thing than shielding an illegal alien from. I mean, certainly there could be overlap in the conduct of committing those two acts, but I think that they're different concepts.
Okay. As a follow-on to that idea, again, the idea of the acting in violation of another criminal offense. To get again, if this were being prosecuted, for example. It seems that the elements of the misdemeanor would be, this concealing or harboring or shielding, and another criminal offense. And those two would, as I read this, again, are elements of the broader offense, which leads to misdemeanor treatment, or a felony if it were enough individuals. How does the other underlying violation play out as an element in this? If it were demonstrated in court, for example, that the harboring and shielding, there's probable cause of that, and that might have been the basis on which the investigation was conducted, and this other offense was identified. And those two then married together to bring someone into court. And let's say that there wasn't probable cause for this other offense, and you lose the other offense because there's not proof of that. And perhaps it's very well established that the harboring and shielding happened, but the other offense might be more sketchy, because that appears to be an element of this misdemeanor?
Well,
Does the whole thing fall apart?
Well, yeah, you as part of it, you have to prove the way as it's written right now. And we've talked a good. I mean, this is certainly something that's open to
Sure.
To discussion. And the motivation here was to make sure we withstand court scrutiny and put language in place that's already been passed on by a federal court. But the way this is set up and the way other states have set it up is these are acts that you can be prosecuted for them, but you also have to have been committing another criminal offense concurrently with these kind of three separate criminal offenses that we've set up here. So harboring, you could be, for instance, you could be in the context of a prosecution for some kind of human trafficking. You could also be prosecuted for transporting, inducing, and harboring. You could probably make a case on all those in that kind of commercial context. So, but you do have to be. You are going to have to be shown that you were acting. The prosecutors have to show that they were acting in violation of another criminal offense at the time they committed these activities.
So as I read this, really, I mean, these offenses really can become a second offense. But there's no circumstance.
Or a third, fourth, fifth.
Right.
Yeah.
Right.
I mean, the whole depending on the. I mean, we could probably sit here and come up with factual examples of where this could arise for the next 4 hours if we wanted to. But again, this is one that I want to hear from the members of the committee on a policy level. So.
Can I ask one further question, Mr. Chairman? Last one was: what are some violations that you think in the course of, and this may be to those that are in the audience just for consideration on Tuesday, I just offer it to the larger body here. What are some offenses that you think in the course of illegal immigrants being in our state, whether it's getting employment, whether it's getting public benefits, whether it's somehow evading detection, what are some existing state laws you think illegal immigrants often might violate in the course of being here in our state?
Well, I think probably the easiest and most readily available example would be in the area of using fraudulent and forged documents. I think clearly in the context of seeking to gain employment, seeking to access public benefits. We have statutes that prohibit the possession, knowing possession of forged documents, the creation of forged documents. I think that's probably, if you're asking me to come up with an example, that's probably the easiest and best example of a statute that is of criminal laws that are being violated on a daily basis by many, if not most, of the illegal aliens that are present here in the state.
I've got a concern, and I would just share it with you for consideration that these disparate violations that exist in state law out there might kind of be overlooked when we're thinking about folks operating in this illegal immigrant context, and perhaps in the interim we could consider. And I would just ask you to consider if there's a way that those kinds of offenses could be brought under the purview of this bill, whether those could be predicate offenses that you'd want to list or enumerate, or tie to the law enforcement being able to pursue action under some of these. I'm concerned that if it's not, and as you've dealt with this so holistically, if some of those things aren't referred to or at least contemplated in these code sections, then perhaps they'll be overlooked.
Well, Representative, I would. Terry and I would appreciate any help we can get in terms of finding ways to strengthen this bill within the parameters of the state and U.S. Constitution. So to the extent that you want to take a look at that and provide suggestions or amendments to strengthen the bill, that only furthers my goal and I think your goal of passing a meaningful, significant piece of legislation that protects our constituents and ensures the rule of law is enforced in Georgia. So I look forward to working with you and hearing your suggestions on those points.
Thank you. Thanks, Mr. Chairman.
Ms. Neal.
Thank you, Mr. Chairman. I think this question is just a matter of protocol. So just say someone's been pulled over, and whether, say, it's 7 people, 10 people, 20 people, in the vehicle that's being transported or what have you, as far as whether it's them knowingly being transported and coming to Georgia, or whether it's unknowing as far as a trafficking situation. What happens then? Is there something in place, or is there possibly can there something be outlined in the bill that makes it where are the local agencies, do they have to set their own protocol, or are we going to establish a protocol through this bill that kind of directs their actions? What happens once an officer stops someone, they say it's a truckload of people, 12 people, the person that's been arrested or has been taken in is going to be taken in for no license, transporting, harboring, things of that nature. What happens to the rest of those people on the side of the road at that moment? What are we doing then?
In terms of getting them transported somewhere else? Or
like I said, if we're not sure about if they're knowingly being transported as...
But that's the kind of thing that will only be fleshed out during the investigation. That's an element of the crime that the law enforcement officer and then concurrence with in concert with the prosecutor are going to have to develop proof that the individual, while committing another crime, knowingly was transporting, harboring, inducing, shielding from detection in the context of committing those crimes. So I think knowledge is an element, and I mean there's a lot of case law on what it takes to prove knowledge across the criminal code.
Well, I guess I'm trying to come from the angle of, say they are being transported and they do know their reasons for coming to Georgia and they're not legal. Being that there isn't they themselves didn't violate the law that the person that was driving did, what's the penalty for those persons that know they're here but weren't driving, they were being transported?
Well, the transporting offense goes to the person that's doing the transporting.
Right.
So I mean the people that are that goes back to kind of the fundamental question or the fundamental issue. Do we have a crime in Georgia, a status crime that arises by virtue of the fact that you're in the country illegally? And the answer is no. I think that's something that would. I don't think we could get past from a constitutional standpoint creating a status crime like that. I think that would be preempted.
So I guess the question is, what happens to those people? What are we doing with those people? Are we since we're not taking them to jail, are we waiting on the side of the road for federal authorities?
No, no, because that is in terms of you're assuming in that scenario that the law enforcement officer has verified that those individuals are in the country illegally. Is that right?
Or something like that.
But the only in the context of this bill, the only way that could have happened is if there was probable cause and they were investigating those individuals on an independent crime, another criminal violation. So, in terms of what happens to the people on the side of the road, that I think Chairman Golick kind of outlined how it happens in practicality is if you take the driver away, you haul the driver off, you have probable cause and you arrest him, then what practically is probably going to happen is the officer is going to ask somebody else, can any of you drive this car? And if one of them says yes and shows the driver's license, and they drive away. But I don't really understand exactly what you're.
Let's stay with that hypothetical you just gave. Say 12 people in the car, the driver is arrested and taken away, and then the officer says, okay, is there somebody else that can drive this car? Say there's another person in there that does have a driver's license. So that'll move that number from 12 that are being transported to 11. That person then gets in the driver's seat and drives off, and they still have 11 immigrants in the back. That's what I'm saying.
But in that scenario, the officer wouldn't know the immigration status of those individuals.
Well, that's what I'm saying. Initially we were talking about as far as just say they did, or they had spoken to the persons in the back and they said they didn't have just any documentation whatsoever.
But
because we need to establish that to make sure that we have a harboring charge for the driver anyway initially. You see what I'm saying?
Right, but that That happens during the course of the investigation. I mean, certainly the officer has the discretion and the ability to contact federal authorities, but that changes in terms of how ICE is interacting with state and local law enforcement officers. That changes on a year-to-year basis based on existing federal law and procedure.
Well, I think I'm just trying to avoid the situation where an officer, say this goes through and everything, an officer just sitting on the side of the road and doesn't know what to do with these people, because sometimes ICE does not or can't come that fast. So you just have somebody on the side of the road not knowing what to do with people.
If federal law authorizes that officer to detain and transport them, they have the authority. They have the authority. We're providing the authority in here, as long as it's authorized by federal law, to detain and transport the individuals in question.
Okay, so I guess you're saying from the standpoint of not necessarily an arrest, but under the guidelines as far as federal law, or just as far as just simply detaining them.
Yeah, we are authorizing our law enforcement officers to take any action that's authorized by federal law.
Okay.
For local or state law enforcement officers to take. We're expressly authorizing them to take those actions that are authorized by federal law. But that's a kind of a fluid concept of what we are authorized to do, because it's a function of federal law and kind of agency procedure at that given time, at that given moment in time.
Okay.
Any further questions for the author? All right, Mr. Ramsey, thank you.
Thank you.
I think what we'll do from a practical standpoint, it's 1:45. I think it would make sense if we held off on public comment until Tuesday, the meeting that I mentioned before at 9:30 in this room. The reason for which really is more practical, and that is that I think it would be beneficial if we and interested parties who want to testify actually had, the latest and greatest substitute that we'll be working from at that time. That goes to the issue of when that would be available for publication, both for members of the committee, because I know there are going to be changes to 2072S.
And if it helps, I certainly would authorize at least what we have right now in terms of a committee sub for committee counsel to make it available to anybody that wants it, recognizing that we're still going to be working on the bill today and Monday and Tuesday, and there are probably going to be some additional revisions, but I think it would be helpful to at least make the most current committee sub. It's not available online. There's not a mechanism to make committee subs available
right.
online. Have a copy available in the committee offices here.
We can.
Brandy could do that.
We can, and more importantly, we could certainly publish it electronically if anybody requests it. But again, being on notice of the fact that the sub itself
it is changing.
Will probably change again. I think from a practical standpoint, if we have people come up here and testifying against a provision which has changed, but they don't know that because they haven't actually seen 2072S, then they're wasting their time and we're wasting taxpayers' time. That's probably not a good idea. So I think we do better to have folks have the latest draft that's available at that time on Tuesday for public comment. I have the sign-up sheets, plural, here. What I'm going to do, just under the category of fair warning, is that there are a fair number of people who have testified under the same organization, and what we try to avoid is what's known as Me Too testimony, and there are several. It's not special to one organization by any means. We'll probably seek to identify the director or leader of a particular organization to speak for that organization in a credible time period, in order to do that, and also certainly to answer any questions from the committee as we have with Representative Ramsey today. And we'll just take that and do the math on 2.5 hours and split that up into a credible time period. We'll work that out between now and Tuesday, and we may do, as Bazemore and I, we may do is just to go ahead and have that done at some point on Monday and post it if we can, just so people know who's testifying for whom. If people are here and they're not with an organization, but they're simply a citizen, by all means, they're going to be able to go ahead and testify. Make no mistake. I will tell you again that the time will necessarily have to be limited because we just don't have all day. We have the room for 2.5 hours. But it will be credible and it will be an open process. Is that clear to members of the committee? Any questions about that? Any concerns? Okay, what we'll do is we'll make 2072S, one other question actually of the author, and to Ms. Long if it's answerable. When do you anticipate being able to have the next substitute, or is that a...
I wouldn't presume to even guess. I hope Monday afternoon, but as soon as I tell you Monday afternoon, it'll be Monday at 7 p.m., and I will have unintentionally misled you, and I don't want to do that.
Okay, then what we'll do is this.
Working as fast as I can.
That's fine. Understood. And what we'll do is this. We'll make this substitute 2072S available. To the extent that a substitute is available subsequent to that, first and foremost, obviously, we'll email that to members. Right. If any individual member of the public calls or contacts in some way and says, is there a subsequent substitute to 2072S available? If it is there, and if members have it, the public will have it. Right. And we can disseminate that electronically as well. There's no reason not to. Certainly be able to make copies here if people happen to physically be here as opposed to someplace else. And then I think that's as practical as we can make it and as workable as we can make it at this point. So, yes, sir. I do. I have it here. Yeah. And we'll consolidate this by organization to the extent that we can. If you're in the audience today and you're a part of an organization where you know more than one member has signed up to speak, if you would let Ms. Bazemore know that you'll be speaking for the organization. If you don't do that, we're going to go ahead and do our best guess as to who is. I'm obviously familiar with Mr. Gonzalez. I can tell you he'll be the person speaking for Galeo. There are other organizations that I'm not as familiar with, so I would leave it to you as members of that organization to please let us know who will be speaking for you as an organization. Anything else from the membership? I think it's been a constructive meeting, and I think it sets a good precedent for our meeting subsequent as we eventually get to a markup. Thank you for your time and your attention. We're adjourned.